I may be pardoned to make a mention. Item number 86 in the weekly list. There, that Puri seesaw lease matter, my learned friend, senior advocate Mr. Das was arguing the other day. In fact, I have intimated the government about the proposal for sitting across the table for a final decision. They have told me that a final decision from the side of government can be taken only after the puja vacation.
Which item is
86. That seashore lease matter towards the north of Southeastern Railway Hotel on the seashore at Puri. That has that area, that 900 people has already been alienated, leased out in favor of tourism department. So some other land nearby, if that is possible, that government will be deciding across.
That is the order, I think. Last
yes,
time.
yes, your lordship had passed that order. I have taken instructions. They have told me to take some time for a decision, the modalities that they will be deciding amongst themselves before inviting the.
You want adjournment? Any objection from which side?
I have taken my friends.
Item number 86 now. This is the last one was passed. Okay.
Sometime towards the middle of November, may I
just let us go.
14 8. Last order was 14 8. No, 21 8. 21 8.
Right, Mr. Ajodhya Das and additional government advocate submits that you are supposed to obtain instruction regarding the readiness and willingness of the state to go for settlement in the petition as per the order dated 21/8/2024. And the matter may be taken off after puja vacation so that the petitioner and the opposite party may be asked to sit together for settlement of the issue to sort out the matter. Mr. S.S. Das, senior advocate, has no objection to put up this matter. You want it done in the month of November?
November. Middle of November.
All right, 11th of November.
11th. I will be out from 4 to 11.
4 to
15th of November.
No, 15th is a holiday. I do not know why.
Thereafter.
Okay, 18th, 18th of November 2020. Interim order to continue.
Appeal bail matter.
Yes, sir. Yes.
Appeal bail matter. 13 years in custody.
My lord, yes, submission for another matter. You lordship already disposed of on similar matters, my lord.
What is the matter?
Matter NH6 National Highway Authority removes the structure of the prisoners, my lord. Already disposed of.
Read a bill.
148 weekly list, my lord. In 148, I made a mention yesterday, my lord. Your lordship has said that if the Union of India's council is there, it can be decided. It's a retired officer.
Both of you are ready.
Yes, my lord.
We can take up next week. Tell us a date. We can.
26 in supplemental list
26. Who mattered?
148.
148, page 28 of your lordship.
148. Mr. Bhavani Shankar Rai, Planet Central Government Council, and the land counsel for the petitioner on consensus of both the parties in this matter on 26th of September 2024. Is there any interim order?
Yes, madam. No, madam. We have got the interim order regarding stay of the
No,
control.
no. Interim order is there or not?
Yes, ma'am.
Interim order is continue till next day.
And will it be in the supplementary list?
हाँ 26 तारीख आने supplementary है.
Grateful. Deeply grateful.
Yeah.
Supplementary list, item number 1.
Council dated 3/9 Malo directed, I undertook before this honorable court that I will be filing an affidavit. That I am filing in course of the day, ma'am.
Why
It can be taken up tomorrow. I am only praying to
Just okay, you are filing it today.
today, ma'am. I will file.
Shall we copy? You can take up
Yes, tomorrow.
And if it serves a copy now, it can be taken up post lunch.
All right.
No, no.
Yes,
I
not
just
made it ready. So the land
Yes.
counsel for the Mr. R.N. Mishral and additional government advocate submits that as per order dated 3/9/2024, he will file the affidavit during course of the day. Let a copy of the affidavit be served on the land counsel for the petitioner, Court of Justice matter on 12th of September 2023. Yes.
Item number 2.
Item 2, my lord. National lawsuit is directed to settle the matter amicably. Accordingly, the London DSA has issued a letter to the department regarding engagement of counsel.
Which order regarding amicable settlement?
Regarding the
Yes, no,
M's,
yes, ma'am.
who is to represent the M's, whether Union of India or panel?
We have issued, London DSA has issued a letter to the department and he has taken 7 days time.
Please go the whether Mr. Padi and his team would represent or the
Yes.
Panel.
There is clear instruction.
Delta would
Yes.
represent. That is the issue.
Issue. Already, Minister has issued letter regarding representation by the Central Government Councils. And the Bhakalatnama also executed on behalf of the administrative officer. He is not a party.
It is an internal thing, you cut it out. So, Mr. Pali, the interim order is there. We are taking up this matter on 23rd September.
I'm filing a status report of the previous ongoing inquiry.
नहीं अपन मानो को भीतर पर एपोर्जन
Let it be, yes.
ये करीब
Your lordship may kindly see the order, earlier order of your lordship.
अब 23 तारीख रे आसु सी आपण कोन बढौचंती आपण गोटे बढौचंती आपण एटा लाइक
Status report.
See, Gotadar Singh would appreciate the
please don't put it off आपण भीतर
No,
who is to represent aims, that is the issue, whether the Union of India, the council or you. So that is to be sorted out between yourself. Why are you putting us in problem?
there is clear direction, madam, by the ministry regarding this case also, madam. Can I have a glance to that letter, madam?
Leave it. So I have only one small request since your lordship is calling from your lordship. 23rd, can we have it priority on this item 1 or 2?
No, we can take up one supplementary list on 24th or 20th.
I have kept it today also, it is.
24th.
The
24th. Yes, 24th.
Mr. Raiguru
24th.
submits that the matter may be taken up a week after, so that a specific instruction can be obtained who is to represent the opposite party number 2 and 3. Mr. D. Lenka, Land Counsel for the opposite party number 2 and 3 is present. Put of this matter on 24th September 2024. Mr. S. Pali Senior
Supplementary.
is present. Talk related.
Supplementary. Wait,
Obviously,
wait,
it will come on 24th.
wait. So good.
Item 3.
Sir, items on behalf of Mr. Gupta, my lord. You will file a written note of submission.
Who will?
My lord.
Item 3. On behalf of Mr. D.R. Gupta, my lord.
D.R. Gupta.
Yes, my lord. He will file a written note. So,
Is the central government council?
yes, yes.
So, when you will file?
And 1 week time.
Who is appearing for the petitioner?
I am on behalf of Mr. Trilochan Ratha.
Okay.
Now Mr. Ratha has gone to the hospital, so he is unable to attend.
All right, take it. We will adjourn the matter. So let it come a week after, so that in the meantime you file your written note of submission and serve a copy on Mr. Ratha. All right. Mention is made on behalf of Mr. D.R. Gupta, London Central Government Council, seeking for time, file the written note of submission for a week. Mention is also made on behalf of Mr. Trilochan Rath, Land Counsel for the petitioner to adjourn the matter. Please, this matter will be commencing from 30th of September 2024. In the meantime, the written note of submission be filed and a copy of the same be handed over to the London Council for the petitioner. The matter to be listed on transfer, indicating the name of Mr. D.R. Gupta, CGC, on the cause list.
Obliged.
Who change it? 37.
Weekly list. Item number 38.
Yes, Mr. Samudra.
May please.
The representation is there under annexure 5.
5 is your representation.
My lord, I filed my lord. And my lord, the whole difficulty is, my lord, some orders has been passed by this honorable court for disposing the representation, my lord. But they are not allowing, my lord.
They are not?
Allowing
it depends upon case to case basis. How do you anticipate that it will not be allowed?
My humble prayer is, my lord, as per the cut-off date may be mentioned in the order sheet, so that it will be.
We are not anything. You let it be disposed of. Then you come. If they say no, then you can challenge it on the. So now you can place every matter of it, or you want that. You want to file a better representation, giving all the details. You can do so. There is no problem.
Yes,
so what do you want? This representation would do, or you want to file a fresh representation?
Fresh representation.
Where is this? Submit that he has filed, though the petitioner has filed a representation details, so and so. But some material aspects are not reflected in the representation, and therefore a petitioner may be permitted to file a fresh representation within a period of 2 weeks, and time be stipulated for disposal of the representation by the opposite party number. Who is to dispose of this? Opposite point number 5. 5. According to disposing so on so if the petitioner the phrase representation before opposite party number 5 elected the project director so on so on within a period of 2 weeks ends, same shall be considered within a period of
Along
3
with
months.
the REIT application.
Along with a copy of the writ petition. So this will this one and communicate the order within 2 weeks there. This is what it is.
Item 30.
Before good child person.
Item 41.
Even may it pleases you, Lord, sir. Lord, sir, the petitioner in all of these matters are the company.
Use it.
Lord.
If whatever child purpose is it.
Lord.
Yes.
The petitioner is a company, Lord, on whose behalf the land has been acquired by the Ministry of Reliance, my Lord. The petitioner is a person interested, my Lord, under the Section 3B of the Act, but without giving any opportunity to the petitioner, whereas he is entitled, the petitioner company is entitled for a hearing, my Lord. But the Section 18 reference has been made, the award is made without the person interested, my Lord, the company here, my Lord. And the award has been passed, my Lord. So I am, my Lord, only here is, my Lord, the matter may be heard, my Lord, in my presence, my Lord. And on similar circumstances, my Lord, this honorable court in batch of matters, my Lord, already remanded the matter. If Lordship permits, my Lord, I will hand over the copy, my Lord, of this honorable court, that this honorable court has already dealt in this matter.
With regard about the this it is a 2021 LMS case and now the award was passed in the favor of the petitioner on 1/3/2024, almost 3 years after. Now again if it is remanded again, so what happened about
that purpose, my Lord, I'm handing over the copy. Lord, so may kindly
how the interest of this petitioner would be
Lord,
petitioner in that LMS case would be said.
That is true, my Lord. In every other matter, my Lord, this honorable court has directed the learned senior civil judge to dispose of the matter within a limited time, my Lord. And accordingly, matters has been disposed of within 6 months to max, my Lord. In all these matters, my Lord. Lord, so may kindly
cannot be passed without hearing the other side.
No, that is true, my Lord, but these orders have been passed, my Lord, as this is.
We cannot say that.
My Lord, my Lord. But the point involved is only on this point, my Lord.
So, but without hearing, it may opposite party number A4 might have objection, the Union of India might have objection. So many, the state is there. So you serve a copy on the state council, so the council for the Union of India. And what is your prayer? Let us see.
Prayer, Lordship will find at page number.
Say that you are a person interested in the case.
My Lord, that as per the concession agreement between the Ministry of Railway and the company involved in this writ petition, my Lord, Lordship will find that in page number 31 of the concession agreement annexure 1. This is between Ministry of Railway and this petitioner company, my Lord. At page number 31, the clause is 4.3. The obligation of the company involved, my Lord, ASRL. Subject to this agreement and applicable laws, ASRL hereby undertakes to do the following: to perform and fulfill at its costs, expenses, and charges all of its obligation under this agreement, my Lord. This suggests, my Lord, I have to complete the whole work, my Lord, as also to pay the compensation to all the land users, my Lord.
Yes.
And where the money is involved, my Lord, if I am the person interested, my Lord, that is why I am saying, because as per Section 3B of the Act of 1894, my Lord, every person who has interest in the land, my Lord, is the person interested. And the company here is paying the money to the land users and completing the work with every person interested, and that has been held by this honorable court in its single bench, my lord, that this particular company is a person interested.
But it will not assign any lien or encumbrance on the concession.
My lord,
See, 43B.
my lord, not to assign or create any lien or encumbrance on the concession
Then,
hereby granted.
then what is your interest?
My lord, that is interest, my lord, and because this honorable court in this company matter, my lord.
No, you are basing your right under the agreement.
Agreement, my lord.
And the agreement doesn't give you this locus standi because you do not have a lien on it. You do not have an encumbrance on it.
Because, my lord, this company has the burden to fulfill the, my lord, any, my lord, award.
So that is vis-a-vis the railway. What do you do with this?
But I have the, my lord, obligation to pay and also to complete the work, my lord.
No. But whatever is there, it is vis-a-vis the railway.
My lord,
it has nothing to do with this.
That is true, my lord. That is why they have made the agreement, because they have transferred all the rights and obligation to the company involved to fulfill the, my lord, the award part and every monetary compensation part, my lord. And the company who is paying the money, my lord, it will not be a party in the reference.
But at the same time, as I again repeat, you have not been assigned or given any lien or encumbrances.
Lord, that part already been dealt with by this honorable court in its single bench, my lord. This honorable court has already dealt that this particular company has the, my lord, right as per the concession agreement, and this
have you annexed that order?
That order,
single bench order.
Single bench order is not there, my lord. The division bench has already passed order saying that this company is the person interested. I have handed over the order, my lord. That's why kindly see that order. I have handed over the order. Exactly on similar point, my lord.
So, what do you say this, the award which has been passed by the learned
Senior civil
judge is on a higher side or what?
Exactly, my lord.
That is your case.
My lord, my lord.
So, this very provision which is there in 54,
My lord.
that also can be taken recourse to that the person who is interested, he can, even though he is not a party, he can file an appeal.
Appeal provision is there, my lord. But the full judge bench decision of the Honorable Apex Court is there. The repetition is also mentioned in the
yes, that is there, but
that is there. And on that basis, my lord.
Before that. You see, once we remand the matter, then everything will start because you'll be given opportunity right from the beginning. It will come the same thing. You can do it because you will claim your right of cross-examination of the witnesses. Everything will just open and it may take a longer period. But if you before the appellate forum, you can raise your grievance, and that will nobody can say that this at your instance the appeal is not maintainable.
my lord.
So let us come to that 54. Let us see
No,
what
no,
it's.
whatever in 226, exercise of 226, we are not reassessing the evidence.
That is true, my lord.
Yes,
But I'm not,
but in appeal, you are getting that opportunity.
but I will not give that opportunity of cross-examination. And because the award on basis of which the award has been passed, it is 10 times higher than the award which has been given by the land acquisition collector, my lord. The original award was 62,000, and the enhanced award is 6,65,000, my lord.
No,
That is 10 times, my
a
lord.
different aspect has been taken into account. It's not that the evidence has been taken into account. The market value perhaps, yes, that is been
The
taken
benchmark of the nearby.
benchmark, yes,
That is not there.
So,
On that aspect also, my lord, I'm challenging the award, my lord. But fact remains, my lord, the only point which I'm focusing on that, my lord, because I have not given the chance, my lord. Because I am the person interested as per this honorable court already held, my lord. So if I'm given the chance, my lord, and usually, my lord, after the remand, in many cases, my lord, usually, my lord, within 6 months, the learned civil judge has passed the award. In other cases, my lord. Also, in this point, my lord, regarding the 226 applicability, I have
we are issuing notice.
No, that is not a substitute of 54. That part we will take care.
Lord,
That is not a substitute of 54.
The petitioner, Honorable Sukinda Railway Limited company, which is incorporated under the provisions of the Company Act 1956, has filed this writ petition challenging the award dated 1st March 2024, passed by the current Senior Civil Judge Kamaksha Nagar in LMS case number 44 of 2021. Which is a reference under section 18 of the Land Acquisition Act. Passing an award of compensation, again the acquisition of the land belonging to the petitioner, the at rupees 6,65,500 instead of 62,000 per acre, as was determined. With a further direction that the petitioner Andhari Adhikari Rao to the LMS case, who is the opposite party number in this writ petition, is also entitled to get an interest of that differential amount at the rate of 9% per annum from the date of which the possession of the land was taken for the first year of possession, and then at the rate of 15% till the date of payment of the excess amount as per section 28 of the Act. The learning counsel for the petitioner submitted that the petitioner with interested party, and as per the concession agreement which was executed between the Ministry of Railways, bracket A, opposite party number 3, and the petitioner company. The petitioner has to pay the compensation amount, but he was not made a party in the reference, nor he was heard, and therefore the impugn award be set aside and the matter be remanded to the senior civil judge, Kamakhya to provide opportunity for the petitioner to contest the case. The Land Council for the petitioner to the attention of this court to the order dated 18/6/2024 passed in a similar case in WPC number 13949 of 2024, where the impugn award was set aside and the matter was remanded for de novo adjudication, giving opportunity of hearing to the parties, including the petitioner. The order dated 18/6/2024 is taken on record. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Land Council for the state accepts notice on behalf of opposite party number 1 and 2. One. Let a copy be of the writ petition be served on the Land Council for the opposite state. The two copies of the writ petition be served on the Land Council and Mr. Party, the Land Deputy Solicitor General, and requisites for issuance of notice on opposite party number 4 by speed post with proof of delivery shall be filed within a week. The matter be listed after 4 weeks a date be fixed. Counter, if any, be filed in the meantime. Yes.
My lord. The other two matters are similar, my lord.
Which matters?
My lord, the other two matters.
Same order.
Same, my lord. Would like to.
The opposite party number 4 is different.
My lord, my lord.
Item number 32.
Lord, in other two cases, my lord, the opposite parties are many, my lord. There are multiple opposite parties, my lord.
Opposite parties for the
My lord.
I just put R for the submits that further submit that even if an appeal provision is there under section 54 of the Land Acquisition Act 1994 against the influence.
And this agreement is only to construction, operation, and maintenance of railway. Construction, operation, and maintenance of railway. We'll have to see on that aspect. This agreement is only for these three things.
Lord, I'll apply sometime. God bless.
But in view of the ratio laid down by the Honorable Supreme Court in case of financial, the writ petition is also maintained as a part of. So that one will be left.
See that. Agreement also is part of the but it agreement due to CETA is it is only in respect to the last page group program that took 1.6/2 page 38. 6.2. MOR is an integral part of the government of India and is the ministry in charge of all activities, including construction, operation, and maintenance. ये तीनटा को समान है एग्रीमेंट में acquisition of land is करना है.
Item 42. Item 42 kindly see for this matter.
Ashuva.
So can you go Friday?
No, Friday it cannot come. It will come next week. If you want an adjournment. Is there any interim order in this case? Or is it fresh matter?
Position.
Yes, matter.
Fresh matter is the position. Bank position.
Right, the Learned Counsel for the petitioner seeks for an adjournment till next week. Let a copy of the writ petition be served on the Learned Counsel for the state. Put up this matter in the week commencing from 17th September 2020.
Item 43.
Okay. Here the present petitioner availed house repairing loan for 1 lakh, my lord. And he has already paid 3 lakh 6,000, my lord. Again, another notice issued for 1.59 lakhs, my lord. So may I, my lord, depict under Annex 2, we have for one-time settlement, my lord. Although I have made an application that has not taken into consideration. May I pray, my lord, I make an application before the bank authority opposite but no one to consider by one-time settlement.
There's a 2017 and 2022 notice has been issued. The notice has been issued sometime in 22.
14/9/2022.
14/11/22. Position notice.
Position notice you lordship Annex 4, my lord. That is 16/9/2023.
The request
So
for
they are settled matter, my lord. 1 lakh I have taken loan house repairing, my lord. I have already paid 3 lakhs. Above, my lord, another 1.5 lakhs they have issued a notice, my lord. And I have suggested by the one time.
You are challenging a notice dated 16/9/2020.
Yes.
A year has passed. Yes. We do not know what is the status of the. Apart from that, you have an alternative remedy. So why will entertain?
Yeah, I am in a position, my lord. Because I am
16/9/2023 ଆପଣଙ୍କୁ ଭ୍ୟାକେସନ ନୋଟିସ ଦିଆଯାଇଥିଲା ଆପଣ ବର୍ଷେ ହେଇଗଲାଣି ଆ ଭିତରେ କଣ ସିଚୁଏସନ କିଛି ନାହିଁ ଆପଣ the petitioner challenged so and so alternative remedy is available. Moreover, the notice is dated so and so. Nothing is brought on record regarding the status of the land in question. What is this land? Yes, land. Land council however submits that he is in possession, the petitioner is in possession of the so and so. Be that as it may, alternative remedy is available. So yes.
No, it's only one line. My lord, is a limitation like that. Limitation.
If any application for combination of delays seems to be considered by the legislation in accordance with law. Yes.
Item 44.
Item 44, my lord. Item 44, there is batch of cases, and in a similar matter, lordship has disposed. That is, I am giving the order now. That is first item is same, my lord. That is WPC 21513 is same.
One is to be disposed.
My lord, that is same. And my lord,
the second sub-item, that is WPC 21515, is also same, my lord.
Unless should be same.
My lord.
So 44, then 44 collected matter. It out the same. Second.
Again, 21515 of 2024 is same. Then thereafter 21518 is also same, my lord. Then, my lord, 21521, that is, my lord, that will be little bit different. Here, my lord, lordship may be kind enough to direct the learned claim commission to dispose of the civil case within a stipulated period. That is pending before the claim commission since 2014 under Annex 1.
Item WPC
21518.
518 na 521?
521. Their notice was issued in Annex 1.
My lord.
Civil case number 896.
Case टा dispose of available. Then case number DIG prayer है ना? So stipulated time दिले. इटा 2016 मसीहा. No, but case number is 610 of 2016 लिखा है जी prayer portion में.
No, under Annex 1 it is 896 of 2014.
What is the CA 610 of 2016 in page number 5? Please come to page number 5.
600. Page number 5 is 896 of 2014, my lord, prayer person.
No. You come to page number 5 and see in your prayer. Civil case number 610 of
brief in WPC number 21521 of 24.
Yes. Mohammed Jafar Alam. Yes.
So what
Mohammed
is
Jafar Alam.
What is the prayer?
Prayer is to
early disposal of civil case number what?
896 of 2014.
610 of 2016.
So, what is the correct case number? Tell us, Mr.
The correct case number is 896 of 2014.
That is reflected in Annex 1. So, you think you correct it, that prayer portion.
My lord.
Learning counsel for the petitioner. It was item number 2151. It submits that the civil case number has been inadvertently mentioned as 610 of 2016 in prayer portion. How सब जगह ठीक लिख जाए?
हाँ, सब जगह ठीक लिख जाए.
नहीं पेपारा 1 ने पुणे से उल्टा लिख जाए वो कॉपी पेस्ट कर जाए.
Copy paste.
से para 1
Para 1 and prayer.
Para 1 and prayer portion. And he may be
para 6 रे ठीक है.
And he may be permitted to correct this. मतलब ये फाइल online file and you will put a hard copy file करो यार page number 2 रो आप गोटे होची page number 5 रो खाली सही
case number
change कर देगी कि case number तो change कर देगी नहीं अब वो आउटर बाहर कर दी print out बाहर कर दी डाल देगा है ना that is disposed of since it is pending since 2016. It is to be disposed of within 6 months. Yes, next one.
Next, that is disposal of the representation under Annex 1.
Same.
So,
next
is 21528. That is also representation of the disposal under Annex 1. Then 21667. That is, my lord,
copy of grievance petition.
Same, sir.
Yes, my lord, same. Under Annex 1, thereafter, my lord, 21673. That is also Annex 1, disposal of Annex 1.
Only one matter is that.
Yes. See, matter এটা আরবি কো নিয়ে আসুন ମୁଁ corrected করে দেই না এগুলা সব ডিসপোজ অফ হই গোটে ম্যাটারটা থাও না ମୁଁ আরবি কে দেই
No, you must have pen drive with you. कौन इटा पेज पेन ड्राइव रे करेक्शन कर देगी नहीं बाहर कर देबे इटा पेज और कौन आदि रह
भाई तुम मोर
মানে অর্ডারটা আজই হবো
আজই অফিস পৌঁছে
আচ্ছা তাহলে তাহলে নেক্সট উইক করবো
গোটে ম্যাଟর থাকবে
এই ম্যাটারটাও নেক্সট উইক করবো
21521
submit likhideve here. The Land Council for the submit that in prayer as well as in the paragraph number 1, the case number has been incorrectly mentioned. The matter may be taken up next week to find the corrected copy of this one. Yes. Pura setup.
setup more it set established.
Item 45.
Single bench eviction matters,
Similar batch matters are pending before the. It's been listed, man. This is the order, malas. Matter relating to eviction, malas. Item 45 and 61, both the matters.
I have created the candidate for the NHA matter.
Page 64, malas, is the notice.
Which National Highway Construction Matter is to be stayed.
Malas, they have issued this eviction notice. I am the recorded landowner.
You will get the compensation.
They are not initiating any process and issuing this notice.
According to us, that is unauthorized occupying the NHA land.
Yes, that is they are authorized by the
As per the land control for land traffic act,
Registered sale deed, everything is
same within 7 days.
No question of stay, granting of stay.
Malas, the batch of matter is pending. Malas, they are seeing. It's pending.
You see the
Malas, there is no survey conducted. Nothing, Malas. Only this notice is issued, Malas. If your lordship will see the notice, they say you will be heard. The date is not specified.
Within 7 days,
only a futile exercise.
Within that 7 days. It was issued within 7 days, you appeared and file your show cause.
Malas, me see it is blank, Malas. Page 5, annexure 5, page 6.
You are challenging what?
Annexure 5.
Annexure 5.
Annexure 5 is dated 29/6/24.
24, my lord. They say,
what is stated in there?
Malas, me see that notice at page 64, Malas.
You are required to remove from such unauthorized occupation within 7 days from this one.
Malas, I'll read, Malas. Therefore, you, Mr. Arun Kumar Lenka, owner of market complex at LHS so and so, NH 53, Tahsil Kujang, take note that you are required to remove such unauthorized occupation within 7 days from the date of this notice is served on you. Stroke pasted on such enclosed building premises. You may make representation within 3 days from the date on which the notice is served on the project director, and such representation, if made, shall be heard on DASH at project implementation unit.
So did you make any
My
representation?
lords, I went to them and made them, my lords. Then I showed them my registered sale deed, everything. There are, my lords, in the stretch of 2 kilometers, they have issued this notice.
No. Have you filed any representation?
My lords.
Let us know clearly.
The representation, my lords, I'll take instruction.
What is the representation?
My lords, I'll take instruction on that.
We filed representation. He is asking that he can dispose of within a week.
My lords,
So we are giving you time
my lords,
to file the representation within a week, let us say, with all your documents, whatever it may be, before which opposite party?
It will be before the project director. SOP number 3.
Project director. Project director is opposite party number 3.
3, my lords.
So that will be considered and disposed of.
My lords.
Okay, reference. The petitioner has challenged the notice dated 29/6/2024 under annexure 5 issued by the opposite party number 3, project director NHAI. The notice is dated 29/6/2024. That the petitioner was asked to submit his representation within 3 days from the from the receipt of the notice to the opposite party number 3, and then such representation is to be heard. When we made a query to the learned counsel for the petitioner whether any representation has been made in terms of the notice under annexure 5, the answer was in negative. However, the learned counsel for the petitioner submits that the petitioner will file the representation, a detailed representation within a period of 1 week from today, and the same may be disposed of by the project director within a stipulated period. You are appearing for whom?
Project director.
The land council for the project director. You have filed your power or what?
I filed caveat, no retribution copies are not taken.
Please give the name so that it can be inserted. Is present, and he also submits that in case the petitioner files the representation within a period of so on, so the opposite party number 3 will dispose of the same within stipulated grounds. So 1 week time is granted to file the representation with the copy of the writ petition to the opposite party number 3. The same shall be disposed of within a period of 4 weeks per year, giving, if necessary, giving opportunity of hearings, personal hearing to the petitioner, and the result of the decision taken be communicated to the petitioner within a period of 2 weeks from the taking of the decision, disposed of.
But still, then my lord, semi-protected.
Till the decision is taken on swan, the petitioner shall not be evicted from the swan.
Great. And page item 61 is also same.
61.
61.
61.
Right. Deepak Kumar Pradhan, same annexure.
Yes. Yes, sir.
Great.
Item 46.
And name also reflected.
Okay. The request will not cabinet petition the disposal of project.
It's a cabinet.
I think.
Let's see the swan, so I can find the cabinet the number swan. But
This is against the order of the London Central Administrative Tribunal.
46.
Yes, madam.
Come to that.
That your lordship annexure 1 is the impugned order. That is at page 25.
Yeah.
Your lordship may kindly turn to page 59, my lord. Relevant at page 59. Paragraph 11. We have carefully examined the issues involved in
note करके
we have carefully examined the issue involved in all the cases and arguments placed in support thereof
with reference to the bylaws of the NWDA vis-a-vis decision of Honorable Apex Court in SLP number such and such and SLP number such and such. So also with the case filed for the CAT Principal Bench Delhi, New Delhi by Sri Rohit Kumar Sethi, and we do not find any substantial grounds to differ from the view already taken in the above cases, especially in view the clear-cut findings of the Honorable Apex Court that the employees of the NWDA are governed under the NWDA CPF Rules 1982. The OM dated 1/5/1987 is not applicable to them, and that the employees of NWDA are not the central government employees at par with their counterparts, and hence their claim of parity with central government employees is defeated.
But here the NWDA was established in 1982 and it is a society that was registered under the Societies Act. Then the bylaw was made under that NWDA that is available at
Annexure 2.
Annexure 2.
Yeah, do one thing, just come to paragraph number 2
of that order.
Of that order.
Paragraph 2 of the order,
That's it.
Yes, ma'am.
Page number 38.
No. See that. It's 38.
Running page 38, paragraph 2.
Yes. In all these cases, the basic grievances of the applicants are that Government of India, Ministry of Personal, Public Grievance and Pension, Department of Pension of Pensioners Welfare, New Delhi, issued office memorandum dated 1/5/1987 for change over to the central government employees from the contributory fund, provident fund scheme to pension scheme, implementation of the recommendation of the 4th Central Pay Commission. In the said OM, it was specifically stated that if no option is received by the date so fixed, specifically requesting to continue under the CPF scheme, the employees concerned will be deemed to have come over to the pension scheme. All the applicants were the beneficiaries of CPF. The OM circulars orders issued by the Government of India from time to time are mutatis mutandis applicable to the employees of NWDA. Therefore, the applicants ought to have been treated to have switched over to the pension scheme, and upon their retirement, they should have been paid the pension and pensionary benefits instead of benefits flowing from CPF. For direction to the respondent to treat them employees under the Pension Rules 1972 in terms of OM dated 1/5/1987 and grant them pension and pensionary benefit with arrears and interest thereon.
Just next paragraph. Read it.
Respondent in all the cases filed their counter contesting the cases of the applicants by stating inter alia that NWDA is a society established in the year 1982 and registered under the Society Registration Act 1860. The NWDA has its own rules and regulations for meeting the functioning and state of affairs. Bylaw 26A of the NWDA stipulates that emolument structure of the employees of NWDA will be adopted with the approval of the Government of India in consultation with the Ministry of Finance, Department of Expenditure. Bylaw 28 states that till such time as the agency frames its own working rules and regulations governing the service conditions of the employees of the agency, the rules and orders applicable to the central government employees shall apply mutatis mutandis to the employees of the agency, subject to the modification as may be made by the governing body from time to time. As per Rule 27A, the governing body of the NWDA society shall exercise all executive financial powers of the society, including those vested, conferred, or to be conferred on it by under any statute, subject, nevertheless, in respect of expenditure to such limitations as the Government of India may impose from time to time.
Sure.
That we, as per the bylaw, will be governed under all the rules
orders issued by the government of India as long as NWDA has not made any such rules governing our service conditions. So it is
whether any rules have been framed by NWDA or not?
No. That's why we came before the learned tribunal, that indicating that since Rule 28 of the bylaw clearly says that all the government of India rules and circulars will be applicable, therefore 1/5
has not yet framed the working rules and regulations.
Your Lordship may kindly turn me out. My praise.
But such a thing is to be adopted with the approval of the government of India.
No matter government of India already framed the rule 1/5/1987. There it has been. Your Lordship, for a moment, kindly turn to page 170.
In order to get it to be adopted by the NWDA,
yes,
we need an approval. That's all.
No matter that, your Lordship, kindly turn to their bylaw itself. What the bylaw says, below. This mutant is applicable. There they have not indicated that is at page below.
Bylaw 26A NWDA stipulates that emoluments structure of the employees of NWDA will be adopted with the approval of the government of India.
Kindly turn to page 97.
In consultation with the Ministry of
Kindly turn to 97, page 97. That rule 28. That will be, they have not framed it. Therefore, in 28 is operating till date. You will also kindly till such time as the agency frame its own working rules and regulations governing service conditions of the employees of the agency. The rules and orders applicable to the central government employees shall apply mutatis mutandis to the employees of the agency, subject to such modification as may be made by the governing body from time to time.
So that is why my lord is asking whether rule was framed or not.
No, but that you will also will find from page 120, 21 below. This is their agenda. You will also kindly turn to 121 below. 121.
No, in the counter affidavit filed, they have also accepted this position that no.
They have accepted. My humble submission, they have accepted that position.
Yes.
Where they have relied upon the one Supreme Court, Honorable Apex Court decision, where the Honorable Apex Court has said, accepted that since the NWDA has framed their own CPF rule, therefore, this circular 1/5/1987 will not be applicable. That your Lordship will find from page 188. Kindly turn, my lord, page 188. Milord, 121, it is of 2000, Milord. There they have specifically indicated except medical attendance rule, no rule has been framed by the NWDA till date. That page 122, you will also kindly see. It is their submission, and not only that, under the RTI, we made the representation sought for the information from them.
So you mean to say that the Apex Court has misunderstood it?
Exactly, Lord. Because
please come to page number 188. 188.
188, Lord. Yes, yes, Lord.
Just 5-6 lines.
As regards the region, Lord.
No, the High Court, the High Court after referring to set up
The High Court
after just 1, 2, 3.
SL Verma's case was correct.
Yes, was correct. The High Court, after referring the clause 6.17 and 7.2 of the OM, held that the employees of the NWDA are not civilian central government employees, as NWDA is an autonomous body working under the administrative control of the Ministry of Water Resources. The employees of the NWDA are governed by the National Waters Development Agency Contributed Funds Rules 1982 and not Contributory Fund India Rules 1962. And in that view of the matter, they are covered under the third situation envisaged under clause 7.2 of the OM dated 1/5/1987 and not under the two situations under clause 6.1 and 7.2 thereof. The High Court was of the opinion that the Ministry of Water Resources ideally should have consulted the Department of Pensions and Pensioners Welfare for issuance of similar orders as on 1/5/1987. However, the Ministry of Water Resources consulted the Department of Expenditure Ministry of Finance in respect of the said matter instead of consulting the Department of Pensioners and Pension Welfare. As regards the regime given by the tribunal on by bylaw 28 of the NWDA is concerned, the High Court opined that their reading of the provisions makes it clear that rules and orders applicable to the central government employees shall mutatis mutandis to the shall apply mutatis mutandis to the employees of the NWDA only in cases where NWDA has not framed its own rules and regulations. NWDA had framed its own CPF rules in 1982 and thus bylaw 28 is not applicable. So Lordship may kindly turn to 133 Miller. Page 133. But this is of dated 29/3/2019 Miller. First point, Lord, information. NWDA is following Contributor Provident Fund Rules 1962 from its inception. This is that information, Miller. And not only that, Miller, your Lordship also kindly see page 238 that this is the basis of filing the case before the Land Tribunal. And here they are categorically indicating that we have framed the rule. When we have pointed out before the Land Tribunal, they have not given any answer. Only para 1, 2, 3, they have given the answer, and all other paragraphs where we have indicated specifically that till date NWDA has not framed any such rule, that they have not replied, never given the reply.
Because that is answered in page 189, saying that bylaw 28 has no role to play in the instant case.
Yes, where once in as per that 1/5/1987 circular, where the department has framed its own CPF rule, in that case, they have to frame the new rule in consonance with 1/5/1987. My humble submission, NWDA has never framed any rule till date. I am not saying that filing of the case. Till date, they have not framed any rules, CPF rules. Till date, the employees of the NWDA are governed under the CPF rules 1962. Therefore, 1987, that 1/5/1987 circular issued by the Department of Pensioners will be applicable.
So you mean to say that the CPF rules in 1982, there is no such rule?
No, that is my specific amendment in my original application, and they have not replied. Still, Learned Tribunal taken note of the Honorable Appellate Court decision. What there was appearing and what submissions were made. Honorable High Court, Supreme Court has indicated, had they not framed the rule 1982 rules, then they could have got this benefit under the 1/5/1987 circular.
To file any application, when you are doubting that such a rule is not there, why are you not filing an application, interim application? That if they say that such a rule is in existence, let them produce that rule.
That endeavor has been made by some of the employees. But the Honorable
when the court was in session over the matter, you are saying that no such rule has been framed. But in the Supreme Court decision and the High Court decision, it is mentioned that CPF rule
has been framed in
1982 and that governs you. So if you say that there is no, but the central government, Union of India says that there is a rule, why didn't you file a application, sir? We have not got any rule, so let them produce that rule.
But
If they say that,
here, Milord, by filing this original application, it was our stand before the law tribunal. Let them to produce the rule. If they will produce the rule, we don't have any case.
No such rule ever saw the light of the
Yes, Milord. This is our specific stand.
How then the court has referred to the specific rule, National Water Development Agency, 1982.
And there some employees were also filed the cumulative petition before the Honorable Appellate Court.
We are appealing for the other side.
But the central government employees, that advocates.
No, this National Water Development Agency, who is supposed to appear for?
There, before the law tribunal, the batch of matters were filed. There, the central government advocates were presenting there.
Nobody is there. Mr. Fadi, of course, he has no problem.
Nobody is there, I can take. If
So,
nobody is there,
Mr. You just take instruction.
yes.
Whether a particular rule is in
Yes,
existence or not.
I was hearing, but while you were submitting, I was hearing.
Just because that is mentioned and he say that entire judgment of the Supreme Court passed, High Court has passed, but there is no such rule. Once there is such rule, obviously he has no case.
No case.
Because this pension matter would be governed under that particular.
He approved 1982.
So we can take up this matter a week after. Just take instruction. We are referring to that.
Give a copy to me.
Right. That rule is, where is that mentioned? The page number के 188 ना ground.
Sir,
189.
133. That no rule.
Yes. Let me know. The
NWDS
was 180
petitioners, so and so, have filed this writ petition for quashing the order dated 27 24/7/2024, passed by the Central Administrative Tribunal, Atal Bench Cutter, in so and so case, dismissing their original application. While dismissing the original applications, the tribunal has taken into account the bylaws of the NWDA vis-a-vis the decision of the Honorable Supreme Court in so and so case. So also the case filed before the CAT PB New Delhi by Sri Rohit Kumar Sethi. The learned counsel for the petitioner submitted that in the aforesaid decisions, it was held that the employees of NWDA are to be governed by National Water Development Agency Contributory Fund Rules 1982. That is page 188. And not Contributory Provident Fund bracketary India Rules 1962. But the respondents have not framed any CPF Rules 1982. And such a rule is not in existence. And therefore, the petitioners are to be governed by CPF rules of 1962. Mr. Bimbisar Das, Central Government Council, Senior Panel Counsel for the Central Government of India, accepts, receives a copy of the writ petition. दे लेता हूँ
हाँ सर दे दे
and in court, let Mr. Das obtain instruction, specific instruction as to whether there is any such rules, namely National Water Development Agency Contributory Fund Rules 1982 or not. And if it is in existence, produce the copy of such rules on the next day, which is fixed. Any 23rd of those and the rules are
24 की सर 24 की 25
of September 2020.
और लग
मतलब सीपीएफ कंट्रीब्यूशन कोथ्रिता है उचे एम्प्लॉय कोथ्रे दोचंती
62 मिला under the 1962
not on 82
I guess ଏବେ ବି ଯିଏ ଆଜ୍ଞା ଚାକିରି ପାଉଛନ୍ତି ସେଥିରେ ଲେଖା ହଉ ତାଙ୍କ ଆପଏଣ୍ଟମେଣ୍ଟ ଅର୍ଡରରେ you are governed under the CPF rules 1962 that copy I will also produce on that day.
All right. Next.
Item 47.
May I please, my lords?
Yes.
I'll be trying, my lord. Some mistakes may be there here while using this one.
No, he is there to assist you. That's why. Once within 2 weeks you will be habituated.
Yes.
You keep the file by side because you might have marked it.
Yes.
But just use it so that it is very convenient. There is no problem, and he is there to assist you. This.
Before going to the papers, my lord, documents, I'll submit that the opposite party initially approached the Central Administrative Tribunal in one original application challenging the order of punishment of dismissal. That only was allowed. The order of punishment was passed. The London Tribunal remitted the matter back to the authority concerned to impose any other minor punishment. That was the specific direction. That order was confirmed in this Honorable Court, so also in the Honorable Supreme Court. So fact remains, a minor punishment can only be imposed on the opposite party. That was carried out. One punishment was imposed. That was as per rule, railway rules, it is under minor punishment. But the opposite party once again challenged.
Let us know what is that minor punishment.
Yes, my lord. If your lordship comes to page 46, it's what it is there in 103, page 103. Lecture 3, page 103. Page 103, that
holding annual pension of paid for a period of 3 years.
Yes, my lord.
So in this case, what has happened? Yeah. You have withheld the
increment. There are two concepts: withholding of increment with cumulative effect or without cumulative.
Here it is cumulative.
Yes.
Again measure.
There lies the craftsman. Your lordship, I invite your lordship's attention to page 103. 103, minor penalty. Your lordship got it? 103. Minor penalties. IV. Withholding of increments of pay for a specified period with further direction as to whether on the expiry of such period this will or will not have the effect of postponing future increments of his pay. Once it affects the future increment, it becomes cumulative. Without, it is non-cumulative. Both are coming in this railway rule. Both are coming under the minor punishment. Unlike other rules, Odisha Civil Service Classification Control Appeal rules, minor punishment without cumulative effect, with measure. That is also in Central Civil Service Classification Control and Appeal rules. That is why I brought the book also. Here, in the railway rules, both are coming under the minor punishment. In terms of the direction issued by the tribunal confirmed by this honorable court, so also by the honorable Supreme Court, we have imposed the punishment. That is coming under minor rules in terms of our rules. That has been quoted by the learned tribunal. So with or without, both are coming under minor punishment. That is how we say it is a minor punishment. Now that has been challenged before the tribunal. The tribunal quashed that order, relying on Supreme Court judgments on a wrong construction. Supreme Court has not committed any use. Supreme Court clearly passed an order where rule permits with cumulative effect is a major punishment, without cumulative effect is a minor punishment. While dealing with that rule, so Honorable Supreme Court has said once with cumulative effect it is a major punishment. But they were not dealing. Honorable Supreme Court didn't deal with the rule of the railways.
Yes. But it was not
Railway is totally different. That is why I have brought my lord. Honorable Supreme Court, before that, may I place that Honorable Supreme Court judge 105, your lordship may kindly see. 104, 105, page 105, my lord. Para 8, Para 8, last lines, last 2-3 lines. Secondly, with cumulative effect, where it will have effect of postponement of the future event. We have gone through the decision of Honorable Apex Court in Rajkumar Goel case, where the Honorable Apex Court has observed as under. The London Tribunal has taken note of this para 12 only. The High Court of Delhi in Uttam Kumar versus Delhi Jal Board 2001-58 DR 342 has laid down the same principle and opined that there is distinction between the withholding of increment without cumulative effect and withholding of increment with cumulative effect. The former is in the realm of minor penalty and the latter is in the compartment of major penalty. In the latter one, there is permanent postponement of the increment, whereas in the former one, it is for a specified period to be released after expiration of the said period. In our considered opinion, the view expressed in the aforesaid decision is in consonance with the sound legal principle. So we approve them. Approve them. Finally, my London Tribunal allowed the prayer of the petitioner. This judgment which has been taken note of, I have brought that judgment for the lordships to see. The Honorable Supreme Court never dealt with.
Just a minute. What is the decision of the Honorable Supreme?
My lord, I am giving this.
Again, that was not also dealing with this railways matter.
No, it is not on railways matter. It is on Delhi Jal Board matter. That also I have brought. That their recruitment rule, what they are following. This is the judgment which has been referred to in that judgment.
In general parlance, it amounts to major
offence. I don't say anything. My lord, in this judgment, if your lordship comes to the third page, at the bottom, page number 7, at the bottom. Third page, last paragraph. In our considered opinion, the view expressed in the aforesaid decision is in consonance with the sound legal principle and we approve them. Coming to the facts of the present case, it can be stated with certitude that trial court as well as the High Court has fallen into error by opining that if the punishment of stoppage of increment without cumulative effect is imposed for a period of 5 years, increment is warranted to be released by the end of the year. It is an erroneous perception of the nature of punishment. When there is stoppage of 5 annual increments, the same are not paid during the said period and thereafter in the 6th year, the increment are added up to the regular annual increment. The employee doesn't get the arrears, but if the punishment is not, sorry.
Yes, sir.
This is interesting. Just before that paragraph, the High Court of Delhi in Uttam Kumar versus Delhi Jal Board. I have brought the law holding the field in respect of Delhi Jal Board. Under the Delhi Water Board Act 1998,
Yes.
Yes.
That judgment relates to how to implement that punishment. After 5 years, it will be given. This Delhi Jal Board I have given, my lord. The judgment related to Delhi Jal Board. The recruitment. Their Delhi Water Board Act 1998. Your lordship will find from the chapter entire document. I have not brought the relevant portion. I have brought chapter 5 in the third page, my lord. 52. Your lordship will kindly see. The service rules as prescribed under the Central Civil Service Control Rule 64 and by the Central Civil Services Classification Control in Appeal 1965 shall apply. Now, your lordship may kindly come to the 65 CCSCC rules. Rule 11. If your lordship, shall I give not you?
No, it's
65. 65.
65.
Yeah, I didn't mark it.
Part 5. সেটা বার করে দଉଛି
CS.
You show your railway rules, manner penalties. Manner penalties in railway.
I understand. This is OCA. It has Odisha Civil Service in that.
What is referred to in 103, page 103, is not exactly that what you are saying. Kindly see your railway rules.
Since it has been reflected in the order of that book, I have not so much.
Oh.
That is my mistake. It has been reflected in the order, that is why
I don't think it is the one that you are submitting.
Madam?
It is not the one that you are submitting.
No, that is the one, madam.
No. Reduction to a lower stage in the time scale of pay
That is
by one stage.
That is another punishment.
That is one stage for a period not exceeding 3 years without cumulative effect. Withholding of increment of pay for a specified period with further direction as to whether on the expiry of such period this will or will not have effect of postponing the future increments of his pay. Where is the very word?
Yes, sir.
Catch word. Cumulative. Where is that?
Future postponement of future increment.
That word is not in your rule. So that is how it has been dealt with. That is how it has been dealt with.
Yes. Your lordship is 100% correct. If the words are not to the tribunal committee goes about that.
No,
but recourse to this. How can tribunal come to a conclusion? If your lordship is correct, if the words are different, taking recourse to those.
But what is your punishment?
Punishment was.
You have made it very specific as cumulative.
Yes, ma'am.
But that is not in your rule again. That is not in your rule. You have made it cumulative.
Your lordship is correct. Your lordship is correct, but that is the meaning. Several
what meaning will come is
several judgments have been
going by plain reading of your rule. It is only when the question of interpretation comes, then we'll see. Otherwise, you have to simply apply the rule as it is.
100%.
And it never speaks about any cumulative effect in the minor punishment.
With or without?
No.
May I read one second?
You read it.
103. 103. Withholding of increments of pay for a specified period, 1 year or 2 years, 3 years, whatever, with further direction as to whether on the expiry of such period, after expiry of that specific period, this will or will not have the effect of postponing future increments. Effect of postponing future increment, whether it is cumulative or not,
make it as cumulative.
What is not there? Your answer is correct. What is not there? But this has been wrong since for long years. This has been interpreted.
It has been by railway.
Sorry, man.
It has been the practice in railway.
No.
Then
everywhere in every law, my lord, in the CCC,
law that has been referred to by Supreme Court and the tribunal. Cumulative has to be a major punishment. So the very spirit of the rule that has been framed in the railway rule has not deliberately, with the wisdom of the authority, they have not put the word cumulative. But in other rules, you will find the word cumulative has been mentioned.
Cumulative has been dealt with several judgments. You are asking me, give me 7 days time, I will produce those judgments.
Suppose, let us interpret in this way. One is getting 100 rupees per month salary. So the increment for, let us say, for 20 rupees per year, let us say. So 3 years, if we say, then for 3 years he will not get anything. He will continue to get 100. So after the 3 year, in the 4th year when he will come, so what will happen as per your rules?
As per our rules?
No, as per, suppose the increment is 20 rupees.
Possibly, I couldn't express properly. Possibly.
20 rupees increment for year, let us say, তাহলে এ বর্ষ যদি 100 টଙ୍କା পাউথান্তা তাহলে ଗୋଟେ ବର୍ଷ ପରେ ପାଇବ 120 ଟଙ୍କା, ତାପର ବର୍ଷ ପାଇବ 140 ଟଙ୍କା, ତାପର ବର୍ଷ ପାଇବ 160 ଟଙ୍କା, right? So 3 years, let us say, stoppage ହେଲା,
4th year ରେ ସବୁଗୁଡା ପାଇବ.
That is not. That is, see the decision.
Let me clarify that. In the judgment also,
ଆପଣଙ୍କ rule ଅନୁଯାୟୀ କେତେ ପାଇବ କହୁନାହାନ୍ତି?
ଆମ rule ଅନୁଯାୟୀ
ଯୋଉଟା ଆପଣଙ୍କୁ ମାଇନର ପେନାଲ୍ଟି ଦେଖଉଛନ୍ତି ସେଇ ଅନୁଯାୟୀ ସେ ଲୋକଟି ଚତୁର୍ଥ ବର୍ଷ ଯଦି ତିନିଟା ଇନକ୍ରିମେଣ୍ଟ ତାର ବନ୍ଦ ହେଲା 20 ଟଙ୍କା କରି ଚତୁର୍ଥ ବର୍ଷ ଯିଏ 100 ଟଙ୍କା ପାଉଥିଲା ସେ କେତେ ପାଇବ 120 ଟଙ୍କା ପାଇବ 180 ଟଙ୍କା ପାଇବ
ଦୁଇଟା ସାରା ହେଇପାରିବ with or without ସେଠି ଯୋଉ ଲେଖା ହେଲା with ହେଲେ ସେ ପାଇବ 120 ଟଙ୍କା without ହେଲେ ପାଇବ 180 ଟଙ୍କା ସେ ରୁଲରେ ଲେଖା ହେଇଛି with or without are coming under the minor punishment which is not available in other statutes ଏଠି ଦିଟା ସାରା ପାଇବ as the punishment is
ଆପଣ ଲେଖିଦେଲେ ଏଠି withhold ଆଉ ଥରେ ପଢନ୍ତୁ
ସାର୍
will not have the effect of postponing the future increment of
future increment ତ cumulation ରେ ଆସୁଛି ନା cumulation ରେ ଆସୁଛି କଣ ଯଦି future increment ପାଇବ ନାହିଁ ସିଏ continuously for the ଏଠି judgment ରେ ଗୋଟେ example ଦେଇଛନ୍ତି Supreme Court if the salary is 100 rupees increment is 5 rupees stoppage of increment without cumulative effect for a period of 2 years then for 2 years you will be getting 100 after completion of 2 years you will get 115 those 5 rupees of the years that is without cumulative effect. If it is with cumulative effect, you get 100. 105. More कहना कथा ये जो rule regular rule रे both with and without both have been taken in minor punishment. That is the crux. Minor tribunal मते कहले जे you impose a minor punishment. We have imposed a punishment which is with the effect of postponing future increment. So it is also coming under the regular rules. It is also coming under minor punishment. That what the opposite party raised before the tribunal saying that it is a major punishment.
will not.
That is what they are saying.
You are challenging. These are the right. First time, no?
First time.
Right. Issue notice on the question of admission indicating therein that the matters are disposed of. Se rule जोटा court है same type रो अच्छी ना कि change in.
No, I'll produce next day because it is reflected. That is why I didn't bring.
The petitioner challenge the authoritated sworn period the rule sworn so जो अच्छी where the minor penalty has been described as follows for the court for the सेटा कितने number page को जनी 103 रे minor penalty रो Roman 4 टाको quote कर दे है ना the contention of this one so that since so far as the petitioner opposite case of opposite party number one since this comes under so and so it amounts to minor penalty. We issue notice on the question of admission indicating therein that the matters can be disposed of at the stage of admission. Requisites for issuance of notice, state post, proof of their
in this case, I am
you are appearing. So,
All right.
so and so, and give a copy subject that he has instruction. You file your day now, or you are
today, for tomorrow.
Please give the name so that it can be reflected. Submits that he has instruction to appear for the opposite party. And you will file the PNAMA by tomorrow. And matter will be listed after so and so they will charge of for it. Counter affidavit you can be filed in the meantime. Serving a copy in the land council for the petition. Yes.
I have filed one IA.
What is the operative part of the judgment?
I have not filed any content.
And then it's all right. Then it's all right.
I can just issue notice for short. Yes. Okay. We are just coming within 2 months.
Pardon my lord. Pardon my lord. Item 48, I have filed a caveat. Yes, I am the contesting opposite party. I pray one time so that I can file a counter that matter.
I have already served copies.
All right.
I have a miscase, your lordships.
We'll hear next week. 1 week is has. So
You see, they are taking steps.
No,
They
will not take steps.
I have received a letter.
the amount is with him.
I have received a letter from IUCL from who has given the compensation to me, saying that if the compensation is not given back, then they will take criminal action against me. So that is the difficulty.
Mr. Ashok Kumar Mahapartha, it was filed the caveat petition is present, and he submits that today he has received a copy of the writ petition from Ms. Naidu, the land counsel for the petition, and he intends to file counter affidavit to the writ petition
Monday
by
next
17th of September 2024. Get a copy of the counter affidavit to serve on Ms. Naidu. Please, this matter to be commencing from 23rd September 2024.
Yes.
Aye.
This is the notice. Unfortunately, I just have the copy. I have not made copies of those. It said they have clearly said that if it is not immediately transferred, they will take action against me. So
IR a copy ওটার মধ্যে দেবে।
I have already served
Very
the
short.
সপ্তাহে তলে file করবো I have served.
So what apprehension is that? What will happen?
I know.
The order is not paid.
File an execution.
No, they have to file an execution undoubtedly, but they have. This is the letter
Yeah.
by the IUCL, which I'm. Yeah. So, I will take criminal action because that is the. Because if they take the money,
In that case, the amount may be posted with the IOCL. I can get interest.
that way I'll deposit it in fixed deposit. That is not a problematic.
You filed with a memo so that we can take note of it.
Lordships. That is it.
Ms. Naidu files later dated so and so of the competent authority, wherein it is mentioned that if the petitioner fails to deposit the said amount within a period
I have taken
within 7 days, or furnish any order of the competent court giving any stay on the operation of the order of the district judge, then appropriate legal action will be initiated against him. There shall be stay of operation of the later dated so and so till next date. এটা পুরো মেমো সেটা দিন।
My lords, may say stay operational the order kind of sorry jibo. Otherwise,
we are just that in pursuance to that no action can be taken. That just give a memo with a memo. You just file it.
Lordships. Item 49.
Please the matter not. The matter relating to this matter not. None of the matter relating to this matter not. My request is pending not. The copy matter not can be answered in a similar or normal pattern.
Annexure 3 is your representation, which is pending before the opposite party number 5, Tahsildar Kanas. The annexure 3 thila, eta annexure 5 hobo, hello?
I also remember similar matter item 16 that I have reflected in 60, my lord.
The annexure number ta kete
7.
60 ରେ କଣ same matter annexure 7 ହେଇଛି no disposal.
Item 50.
Wait, please, minutes. Because the petitioner is a proprietress of Tirumala Traders, which is a small scale unit, Millets. It is in the supply and trading of electrical goods, Millets. Now, Millets, SBI provided financing facilities of 1.43 crores towards CC loan, and there is one GECL loan for that 22 crores. 22 lakhs, Millets. Your Lordship will kindly see page 18.
You have received the 13-2 notice.
13-2 notice.
Which you are challenging.
Yes, Millets. 13-2. I'm challenging the 13-2 notice.
No, you can take recourse to 3 is the
13-3A Millets is there, but your Lordship will see.
To this court.
Your Lordship will see.
And this type of matter, it is not maintainable here. So, 513.
Yeah. Your Lordship, so my only submission, Millets, regarding 13
submission. This alternative remedy is there. Moreover, this provision itself, statutory remedy is there.
Yes, so it's not an efficacious because what it does, Millets will kindly
what
see.
It does, it do not know. What they do, that is not matter. But you have to first avail the.
Millets will kindly see 13-3A. If on receipt of the notice under subsection 2,
yes,
the borrower makes any representation
or
raises any objection, the secured creditor shall consider such representation or objection, and if the secured creditor comes to the conclusion that such representation or objection is not acceptable or tenable, he shall communicate within 15 days of receipt of such representation or objection the reasons for non-acceptance of the representation or objection to the borrower, provided that the reason so communicated or the likely action of the secured creditor at the stage of communication of reasons shall not confer any right upon the borrower to prefer an application.
So first you avail.
So my humble
submission is different. 13-3 you have not availed, or you have availed it already.
No, I am not availed. Plus the declaration of NPA itself is illegal.
Right, 2020.
Your Lordship may give me that
notice is challenged. The Land Council for the petitioner submits that no representation has been made in terms of 13-3A. That the petitioner make a representation in terms of so and so within a period of 1 week from today to before this one. So in the event of which the opposite party number
1
will dispose of the same in accordance with law. We are making no finding on the merits of the case. Okay.
Yes. Great.
Dispose of it. Next.
Only thing, if your Lordship will consider, by taking into account the circular
of is appearing for State Bank of India.
I am appearing. I have an instruction.
Right, we are mentioning your name. You take your fees.
Miller.
What is your name?
Miller and Dilip Kumar Mahapat.
Mr. Dilip Kumar Mahapat, Land Council for the State Bank. Yes, next.
By your Lordship would observe, by taking into account all points of law raised in this
petition. Necessary by giving personal hearing to the petition.
Miles. I'm so grateful.
Item 51.
No, you finish it. 51.
Item 52.
This is land acquisition matter. Petitioners have filed their objection to determination of the compensation amount by the annexure 4. I have filed the cover matter. Similar order
Annexure
5 matter.
You got a copy?
Annex correction.
Get a number.
Annexure 5.
Annexure 5. Acha. সেটা হচ্ছে objection filed by annexure 5 ଅଛି ଏଠି annexure 4 ହେଲା yes annexure 5 ଅଛି ସେ ଅନୁଯାୟୀ disposal କରିବେ all right all the ସବୁଗୁଡା ସେଇଆ
ଆଜ୍ଞା
Item 54.
Mr. Mishra, may I please?
Annexer 4 was issued to me at page 13 to receive the compensation amount under the Land Acquisition Act. The date was fixed on 28/8/24.
Right.
On 28/24, I appeared before the Land Acquisition Officer and submitted an application purportedly under section 64 that there may be reference to the competent authority. That application is not considered. 28/8.
What? ଏବେ ତ 15 ଦିନ ବି
ସେ କିନ୍ତୁ ଚାହୁଁଛନ୍ତି ଯେ ମାନେ
ଇଆଡେ ଫାଇଲ କରି ଇଆଡେ ପଳେଇ ଫାଇଲ ସାଙ୍ଗେ ସାଙ୍ଗେ
because he threatened that he will disburse the amount by apportioning. That is my grievance.
Alright, petitioner has application in filed was the no reference has been made. So act upon the application within a period of 2 weeks from the date of production of the certified after receipt of the notice under annexure 4, the petitioner submitted an application by annexure 5 for reference to the authority for deciding and making comments according to the entitlement as per law regarding apportionment and disbursement of compensation amount. Land Council submits that till date no reference has been made. It is with copy of the order with the copy of the writ petition is filed. It is to be reference is to be made in terms of so on 64 within a period of 2 weeks from the date of production. Disposed of. Yes.
One prayer, no disbursement till he considers the application.
No, you just produce, I think.
If a disbursement is made, then I will be running after the.
But such a
without hearing the other side, we are just disposing of the threshold. So many opposite parties are there.
They are the beneficiaries, my co-sharers.
So, like whether you are entitled to get or not, or all these things have to be decided by the after making reference, and what would be your share also. So that is to be adjudicated at the appropriate stage. Why no disbursement? Why pass that order, particularly without hearing them? To make that application.
Annexer 4. My entitlement is not in doubt.
No, it's all right. Now you say that you are disputing that entitlement. That you are entitled
apportionment. I am entitled
to get more, right?
Yes.
But unless we hear the other side, we cannot stop it or say. And there is a provision also, even if you have something has been disbursed and he is not ultimately entitled to, that can be taken back, returned back, and
again it is a conversion process.
It's all right.
For 2 weeks, if it can.
So, next.
Obliged.
Item 56.
55 already. Mr. Dhoni.
Lordship, here also, Lordship, only representation to be considered at best. Lordship, Annexer 1. I am covered under the Lordship circular of the government 1510 being the grandson of the Lordship land losers.
No, Annexer 4 is to be disposed of.
4 is to dispose of, Lordship. Lordship, collector, Lordship, collector and land action officer. That is before the land acquisition officer, Lordship. But collector and 3 and 5 Lordship.
Each and the representation.
Each Lordship. Annexer 4, page 30.
30?
Page 30, Annexer 4.
30 रे तो लिखा है जी स्वतंत्र
भूर्जन I have land acquisition officer, special land acquisition officer, Lordship.
से करिए
से तो opposite party number 5 है
5 Lordship.
से करिए
हां से कलेक्टर टा जोड़ देले सुविधा रही जाउछ
कलेक्टर हां करिना रिप्रेजेंटेशन को आनिबे
ना इन फाइट Lordship
you make a representation of
I will make a representation, Lordship.
Annexure 4 is to be disposed of. So if any application is made, Land Council so submit that the petitioners intend to file a similar representation before the opposite party number 3 within a week. If the same is met, same shall also be disposed of in accordance with law. Time stipulated by the
Upon the 21973.
In view of the lordship
21973.
73 lordship.
ତାହେଲେ 73 annex 3 ରେ ଆପଣ ଜିଲ୍ଲାପାଳ କରୁଛନ୍ତି
ନାଇଁ ସେଟା ଲordship there is a confusion ମୁଁ ଆଗରୁ
ତାହେଲେ you make fresh
ନା fresh annexure 4 fresh I fresh ha lordship in view of the annexure 1 lordship so that is the notification 15 11 10 page 14 lordship.
How much have been pleased to decide that the grants and so on so forth from এইটার কোন পুনি পরে কোন ହେଇଥିବ কি ଜାଣିଛୁ
ନାଇଁ ଆଉ ହେଇନି still lordship
ତାପରେ
କହିଛନ୍ତି you have referred to that
copy of the writ application lordship is
copy of the
writ application
press representation is the copy of the representation yes.
Here lordship next item annexure 3 series here the collector ପାଇଁ ଅଛି
এটা হচ্ছে collector disposal
lordship
Mr. Dorai, this representation matter you ask your associate to argue the matter.
Lordship, in fact, there is little confusion. Sithe mu asilu na asinu.
Pakke chhida hi na diyantu se karibe.
Lordship.
Yes.
Lordship. Yes.
Item 59.
May I please refer, Lordship? My Lord, this is a matter where the petitioner in the year 1964-65, the government of Orissa issued an information to the public that they want to lease out certain lands.
You are challenging the order under annexure 2.
Yes, my Lord.
ADM.
I have challenged the order.
By Swanto in revision case number 1. Okay.
Yes.
What has been held in there?
That he has rejected my petition that I have not produced all the documents, my Lord. That is the only ground.
Just show that operative part of the. It is at page number?
Page number 19, my Lord.
No, you come to that 29. Operative part. In view of the above, I am of the opinion. Say to Paresan. Annexure 2 ro jotaku the petitioner has challenged this annexure 2 na
no annexure
please see your prayer
yes
59
kitna manga item
59 mal 50 item 59
we are in okay sorry we are in 58
annexure 2 is rent receipt mal
Yes. No, you see,
item 59, man.
59. But your prayer is to direct the opposite party number 2 and 3 to record the name of the petitioner in this one. So that is prepared by the ASO.
Yes, madam.
The covered matter. So Narottam is there.
I am because annexure 1, your lordship may kindly turn to page 11, madam. The draft quota given by me in 1969, though I was granted lease in 1965, and thereafter I am paying rent. Annexure 2, page 12, till 16 and 17 I was paying rent, and in the year 2013.
Where is the order passed? Which you are challenging?
I am challenging the order. Your lordship may kindly turn to page
20.
Page 20, madam.
Page 2021 रे order हल्ला
yes
हाल plot number एतिकी रे
my ex party since I have not produced all the documents for them
and page 20 পর্যন্ত
2021
record is put up today
Padmal
yes
20 পর্যন্ত order dated 22/4/2018
yes my lord 22 Nispati it is written in English. The petitioner has not filed all the page 21, my lord. Petitioner has not filed all the relevant documents in support of the claim, and the case is disallowed for want of necessary documents. My lord,
what he could have done, and moreover, I think we think that ASO or a order against a So there is a provision, Mr. Das, which is that provision? Why did you straight come to the High Court challenging the ASO order?
Because it's an
No, there is alternative remedy. Which act it is?
Which of Service Settlement Act?
1958, and the provision is the alternative remedy
12A.
12A. An appeal if presented as a so shall lie from every order passed by the assistant settlement officer under section 12 of the settlement act. So appeal provision is there.
ଯଦି ଫାଇନାଲ ହେଲେ 15 ଟା ଯିବେ ଫାଇନାଲ ପବ୍ଲିକେସନ ଦି ରେକର୍ଡ ଅଫ ରାଇଟ୍ ନଟ୍ ପ୍ରିପେୟାର୍ଡ ଇନ୍ ମାଇ ନେମ୍ ଦ୍ୟାଟ୍ସ ସୋ ଇଟ୍ ଇଜ 12A. That's why I have not given you the copy of that matter.
No. Now you can file an appeal under 12A.
Yes.
If it would have been the final publication, that is under 12B of the then
15B of the
15B.
Final publication
12B रे 12B order against like karibo section 15. That is right. You are right. That is revision by before the Board of Revenue. So now your alternative remedy is under 12A.
Final publication
already I have written in my petition also. 2013 there was final publication. Then yes, madam. I am coming to that, madam. Your lordship may come to has rejected the appeal only. The man Ponnai my lord, page 6, my lord, page 6 of my brief.
ଦୁଇ ହଜାର ତେର ମସିହାର ଗୋଟେ ଅର୍ଡର ଆପଣ ଆସି 2024 ମସିହାରେ ଇଏ କରିବେ ସେଟା ହଉଛି ଏସୋର ଅର୍ଡର ଆଉ କିଛି ଆଭରମେଣ୍ଟ ହିଁ ନାହିଁ ଆପଣଙ୍କର ମାନେ ଡିପ୍ ସ୍ଲମ୍ବରରୁ ହଠାତ୍ ଉଠିକିନି ପଳେଇଲେ 11 ବର୍ଷ ପରେ ଅର୍ଡରଟାକୁ ଚ୍ୟାଲେଞ୍ଜ କରିବା ପାଇଁ
that is the lease granted in 64-65
ଏକ ହଉଛି ଡିଲେଡ୍ ଦ୍ୱିତୀୟ ହଉଛି ଅଲ୍ଟରନେଟିଭ ରିମେଡି ଆଭେଲେବୁଲ ତ କେମିତି how you get the relief? And no finally publication has been made.
Section 20 ଯଦି incorporate to render
ଖାଲି 13 ଗୋଟେ ଅର୍ଡରଟାକୁ ଚ୍ୟାଲେଞ୍ଜ କରୁଛେ ତାପରେ କଣ ହେଇଛି କିଛି ଟୋଟାଲି ନାହିଁ
because in 54-13
sorry we give you that if can avail that because it may so happen that appeal has been already filed and it might have been disclosed.
No, appeal has not been filed, man.
ଯୋଉ ଅର୍ଡରଟାକୁ ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି ସେଟା 11 ବର୍ଷ ତଳର ତା ଭିତରେ କଣ ହେଇଛି କିଛି ଆପଣ ଦେଇନାହାନ୍ତି ଦେଖନ୍ତୁ the petition has been filed by the petitioner Prasanna Kumar Das challenging the order dated 13
page 19 paragraph 19 I have stated
22/4/2013
in July 2013 the final publication was made, my lord.
Passed by the assistant settlement officer. The court election government
Para 19 the final publication of record
19 Yes. Government has been made that the final publication of record of right in Simli Patana Moja was published in the month of July 2013. However, no documentary proof has been annexed in support of such government. Be that as it may, since under the Orissa Survey Settlement Act 1958, against the order passed by the Assistant Settlement Officer dated so and so, or against the final publication of record of right as per section 12B, if any, the alternative remedies are available. We are not inclined to entertain this writ petition, which is accordingly disposed of. Yes.
May I submit one thing?
The petitioner is at liberty to approve the appropriate forum. Yes, next.
Item 63.
May one line may kindly address. But your lordship may indicate that I will approach the authority. Authority will consider wrong filing of the matter. Wrong filing of the writ petition and that section 14 of the limitation.
Limitation of the appeal.
Yeah, Mr. Within a year, madam. They will hear it after 12 years, decade.
If any issue of limitation arises in filing, approaching the appropriate alternative forum, and an application for is filed for condonation of delay, the authority can take into account the filing of the writ petition and section 14 of the Limitation Act in accordance with law. Yes.
Your lordship, the petition is challenging the order passed by the district collector, magistrate, page 24, annex 5, my lord. Earlier, this petitioners are before this honorable court, and as per the honorable court order, the collector passed a baseless order, as because the petitioners are entitled to get the benefits according to the RR policy, and also the damage and other benefits.
Discussion kori 3 page of the order pass korchen baseless kon egala.
Because they have stated that 12 persons remaining there, but so far as 446.
Please come to the operative part of the order of the collector.
Yes, my lord.
That operative court, after hearing both the parties, say the person. Last page.
Answer 5, page 24.
26 person.
26.
Here, sir, page 26.
After hard that property part. Last part of the order.
Yes, after
hearing
the undersigned conclude that employment and other RR benefits have already been provided to the
family of the petitioner. Family of the
petitioner, and the employment and other RR benefits would be provided to the balanced families. We are on balanced families. Balanced families after completion of assessment for compensation subject to cooperation by the tenants, villagers. The petitioner and his followers are directed to cooperate the MCL authority for assessment of their assets. According to the petition filed by the petitioner, is rejected and the case is disposed of. So I am challenging that order. Whenever they have stated that they have not cooperated, and also only the order passed, according to kindly have a glance, the upper line, same page, page 26, upper line. Monetary benefit 2 lakhs in favor of each of eligible residential has been sanctioned, and the petition is also included of the same.
2 lakhs is not sufficient for that because they are residential house and they are own property. 2 lakhs is not because Jorabaga and other villagers are also entitled to 8 lakhs, but they have stated that 2 lakhs 2 lakh kichi habani.
So the compensation amount according to you is not adequate.
Yes, my lord. So I am saying
what is the provision for that? Go with the provision.
Yes, my lord. I am first coming on the point of section 13, payment of damage.
You go for redetermination 64.
There is a provision.
64. Collector.
Yes, so
you go for redetermination. Don't go for the you are asking for the compensation again. Redetermination. They say that you have paid. They have paid. You say that it is not sufficient.
No, we have not received. Till date we have not received.
Then 64 is there.
Yes.
You can go.
In the 64, that is the collector is the authority. Here is passed. The collector was passed this order on and have a glance. That the collector and district magistrate.
No, put it under 64.
64 is to the power with the collector to refer the matter for determination by the authority. If he is dissatisfied with the amount of compensation and you have not accepted that, then you can file an application for reference of that matter to the appropriate authority. That you have not done. You have come straight to this court. That is what been indicated by my brother.
Why I am coming this manner? Earlier these petitions are before this honorable court.
Whether say jomiro jo valuation apanakar ye valuation सेटा अधिक कि कौन सेथिपाई आपण असेस करिया दरकार वे तो साक्षी नबा पई दरकार हे पारे तो से जिंस रीट कोर्ट रे कोड हे परिबो now आपण जदी एप्लीकेशन देबे एप्रोप्रिएट अथॉरिटी को सेटा मैटर टा रेफर होबो सेठी आपण कहि परिबा आगे से पाखा पाखी जमी गुडा को एई रेट अछि सेठी मोर एई घर अछि तार वैल्यूएशन होछि एगुडा को सब आपण करले से एटा को रीडिटरमिन करिवे जे आपण हायर कंपेंसेशन पाइबा पई पेत हकदार एवं एप्रोप्रिएट ऑर्डर कैन बी पास सो देयर इज ए प्रोविजन ऑलरेडी अवेलेबल टू यू अंडर दिस स्टैट्यूट you have not availed the same directly come to this court by filing this writ petition so you file an application in terms of section 64 of the 2000 for reference make a prayer and there is a provision also if the collector fails to make the reference then you can go to the apply to the authority and make a prayer that asks the collector to make the reference that is there in the provide
you can go direct in that case if the
in that case so alternative forums are available to you all right
because now they are trying to garb that and they have forcibly
आपण पैसा पाइबे पैसा ऑलरेडी आपण सैंक्शन हेछि आपण नेई नाहंती आपण कहउछन्ती आ अधिका पाइबे 2 लाख हेछि आपण 8 लाख पाइबे केमिति पाइबे से बाटो स्टैट्यूट रे देइछि आपण से बाटर न जे ये बाटर आसले पाइबे केमिति
now they are trying to भांगी दबा को वसंती फोर्स लगाई करी सेट में पेपर
this writ petition has been filed by petitioners it was the order dated 6/12/2023 passed by the collector and district magistrate Jharsuguda opposite party number 3 had annexure 5 the collector in its order dated so and so has held that with regard to RCP Pada, MCL authority submitted that the resident of RCP Pada, Jurabaga, have constructed house over the westland of MCL, which is very close proximity to mine working of Belpahar OCM in order to smooth shifting of the MCL land, monetary benefits of rupees 2 lakhs in favor of each eligible resident has been sanctioned and the petitioner is also included for the same benefit. The Land and Council for the petitioner submitted that it is a homestead land and there are your case is that it's a homestead land.
There one sir. Now
and
they are living there before their forefather.
And the houses have been constructed thereon, and the compensation amount should be on a higher side. And moreover, the petitioners have not received the monetary benefits as yet. Section 64 of 2013 Act provides that if any person interested who has not accepted the award can, by written application to the collector, require that the matter be referred by the collector for determination of the authority, inter alia, the amount of compensation. And the second proviso indicates that if the collector fails to make any such reference within the period so specified, the applicant may apply to the authority, or the case may be, requesting it to direct the collector to make the reference within a period of 30 days. Admittedly, the petitioner has not availed the remedy available under Section 64 of the 2013 Act. At this stage, the Land Council for the petitioner submits that permission may be granted to the petitioner to submit the application before the collector for making reference to the authority for determination of the amount. If any such application is made within a period of 2 weeks from today, the same shall be taken into account and appropriate order will be passed. However, we are not expressing any opinion on the merits of this one. Disposed of. Yes.
No coercive action shall be taken in the meantime.
Yes.
No coercive action shall be taken in the meantime.
You are entitled. They are to get the land. You are only to get the compensation, whether it is 2 lakhs or 8 lakhs or whatever it may be. All. So.
Second appendix.
Supplemental list, item number 1.
May I please? The sole appellant is Mr. Lordship being convicted of 302 IPC and sentencing to undergo life.
Did you have you got that custody certificate?
Mine.
କେତେ ବର୍ଷ ହଉଛି?
8 years.
2016 ରହିଛି 25/7/2016. 8 years 1 month ହବାର ଅଛି.
1 month.
8 years.
Okay. Yes, Mr. Master.
Here the Lordship can see on the basis of the evidence of PW1, who is believed because the informant died and the PW1 has signed the FIR. And extra witness has been given and the appellant is found guilty. That with the evidence of PW3 and PW3, the so-called witness is the only PW1.
PW1 is the eyewitness.
So-called, yes.
Okay. And who is the doctor who conducted
6 and 9, my lord. 6 and 9, double murder case.
Okay. 6 and 9.
My lord.
Brother and father.
My lord.
Say, not a single eyewitness.
PW1 is the eyewitness.
My lord.
She claims to be there.
Okay, let us go through it.
And not a single eyewitness, the villagers are examined independent witness. These are all relating to within the family and interested witness. And
just place that PW1
if appellant even so further he had no funds to engage a private counsel as state defense counsel defended him in the trial court.
Okay.
And he didn't move also earlier during trial or any time.
PW1 evidence place.
I know the informant who is my mother-in-law. I know both the accused persons present in the dock, who is my brother-in-law and sister-in-law. I know the deceased person who are my younger brother-in-law and father-in-law. The occurrence took place on 24/7/2016 and at about 8 a.m. in our bari as well as in our courtyard. My husband has got 3 other brothers since 2010. There was disturbance in the family relating to partition and disturbance of family properties.
Distribution of family
My lord. Distribution of family properties. Both the accused persons were always threatening to take the lives of my father-in-law, other brother-in-laws, and my husband. On the date of occurrence, my youngest brother-in-law, Samanta Dole, was busy in some agricultural work in our bari. By that time, both the accused persons went to that place, and out of them, accused Santosh Dole dealt blows on the head of Samanta Dole by means of an axe. Accused Dinna Dole was standing at a little distance away from the accused Santosh Dole. In my presence, Samanta Dole fell down on the ground with severe bleeding injuries, and I rose towards him with a glass of water. Since Santosh Dole threatened to take away the life of my husband and rose towards me, threatening to attack, I rose to my house out of fear. I raced out and called the villagers to the spot. After brutally assaulting Samanta Dole, accused Santosha Dole was standing near my house in a hidden place, and when my father-in-law went to that place, suddenly accused Santosh Dole attacked him by means of same axe, as a result of which he sustained severe bleeding injuries on his head and neck and died on the spot. Since the accused was terrorizing everybody, the villagers called the police, and after arrival of the police, he was captured on the spot and took accused Santosh to the police station. Thereafter, my mother-in-law, Lakshmi Dole, lodged affair at the PS. Now my mother-in-law is dead.
So PW1 has stated that villagers called, but PW3 has stated that out of fear he came out of the house and he telephoned. And the police says that I do not know who.
Those are the matters which is to be considered at the appropriate stage. You assaulted both the deceased. One is Samanta Dole and the other is Gopinath Dole, and the weapon of offense is axe.
Examination in chief.
Yes. So
many things they have developed. If your lordship will go through the evidence of PW23 IO, the cross examination, how they have developed the story, it is relevant, and moreover, the investigation is out and not perfunctory. In the sense, both of PW1 and 3 have stated about the large number of villagers came, but not a single villager has been cited as a witness. Here, not a single villagers. The PW1 also says that villagers came. She shouted, villagers called the police. But the police is not saying, so who took him to the spot? Who called him? The IO, PW23. So virtually the entire prosecution is a perfunctory one. And
the PM, the doctors have noticed on the
then serious discrepancy in that level also. So far the assault party is concerned and the injury found on the body.
Yes, Mrs. Sahoo, come to PW6.
On 24/7/2006.
So there are 3 incised wounds on the temporal region.
All in the head.
2 is on the so and so, and another one on the neck and 2 on the head. Then the other one.
The other one is PW9.
Cause of death, craniocerebral injury. PW9.
Chop wound over left side of the neck.
Chop wound, PW9.
Chop injury in the head.
Forehead.
Contusion over forehead.
Neck.
Laceration back of head.
Forehead. Yes, Mr. Mishra. A very serious injury.
There, but nothing. So the evidence of the PW1 and 3 and the injury, if they are inconsistent.
Yeah.
That's all what is there before lordship. There is, your lordship said, this question of prescription at the time of hearing. But here also he has already stayed more than 8 years and not a single day he was released. Because of his poverty, he never tried also. He neither removed the High Court nor he was released on parole. So he has already stayed more than 8 years, and the appeal is not likely to be disposed of before my death.
2024 appeal, so no question of early disposal because
That is the thing. It would take minimum 20 years because I have got appeals of 20 years back.
24 appeal, there are old appeals have been pending.
That is the reason. I pray that if you will also see the evidence of PW 23 for a moment.
Yes.
The contradictions, the IO, what he has given,
Which paragraph, Mr. Mishra?
The cross-examination portion of the PW 23.
PW 23, which paragraph?
Also, can you see?
So far as PW1 is concerned,
my lord,
the only contradiction that has been pointed out is in paragraph 23. It is a fact that the witness PW1 has not stated before me during investigation that after brutally assaulting Samanta Dale, accused Santosh Dale was standing near. That is the only contradiction which has been brought out. Otherwise, about the assault on each of the deceased by means of that axe, there is no such contradiction, and that is corroborated by the medical evidence which is adduced by PW6 and
that is fine, because but the whole point is that PW1 and 3 have consistently stated, and the PW23 is also stated. Villagers were there. So why not a single villager or one or two
villagers not examined? That is your one of the submissions.
This is vital, my lord, because they completely he has not tried to find out the truth. Metal parrot like whatever they said recorded, and the PW3 is saying that I intimated him over phone, and the IO is saying that I don't know who I intimated him and who took him to the after village to the spot. So everything is confusing. The truth is far away from what is there in the record. Mechanically, there yes, there is allegation, but the whole point is that there is serious deficiency in investigation to find out. He has already stated.
Petitioner and Mrs. Sumarani Sahu, an additional standing counsel. As per order dated 2/9/2024, the London Council for the State has produced the custody certificate issued by the Superintendent District Jail Balangir, which indicates that the petitioner is in custody for 8 years and 1 month. The custody certificate is taken on record. Mr. Mistral and counsel submits that the PW1 is an eyewitness to the occurrence, and he is related to both the deceased, that is Shamanta Dori and Gopinath Dori, and the evidence on record indicates that co-villagers were present at the scene of occurrence, but the prosecution has not examined the co-villagers to speak about the occurrence. It's further argued that there are inconsistencies in the evidence, and since it's an appeal of the year 2024, there is no likelihood of early hearing of the appeal. Therefore, the bail application may be favorably considered. London Council for the State, on the other hand, placed the evidence of PW1, who has stated how the petitioner assaulted both the deceased by means of axe. She also praised the evidence of PW6, who conducted post-mortem examination over the dead body of deceased Samanta Dole, and the doctor has noticed as many as 3 sharp incised wounds, 2 on the temporal region and 1 on the neck, and opined that the cause of death was due to craniocerebral injury. London Council for the State also placed the evidence of PW9, the doctor who conducted post-mortem examination over the body of the deceased Gopinath Dorai, who has noticed one chopped wound on the left side neck, one contusion on the forehead, and laceration on the back of the head, and opined that the cause of death was due to multiple chopped head injury on the of the brain, hemorrhage saw. Land Council submit that since it's a case of double murder, the petitioner should not be released on, and there is direct evidence which is corroborated by medical evidence. The petitioner should not be released on bail. Considering the submission made by the Land Council for the respective parties, in view of the evidence of the eyewitness as well as the evidence of the two doctors who conducted post-mortem examination and the nature and gravity of the accusation, we are not inclined to release the petitioner on bail. However, the petitioner is at liberty to renew the prayer for bail after 1 year. Yeah. IL numbers 1, so there shall be sterilization of file. Yes, next.
Can he be released for some temporary interim bail maximum
after 1 year? We'll see. Yes, Mr. Passover,
Passover item number 7.
Next.
Item 17. Item 19.
Please, Your Lordship. I am there virtually. Lords, I am pressing IA number 2021 of 2024. There, Your Lordship was pleased to call for a report, my lords.
Just a minute. 2010 counsel for the petitioner submitted a petition with age of 56 years, suffering from various ailments. He was also admitted to Anandapur Hospital for treatment. Health condition is alarming. Medical document has been annexed. State seeks some time. Obtain specific instruction on paragraph number 3 of the interim application. Paragraph 3 the small election the
76
one so all such ones always is there. It may cause the ulcer and symptoms.
Judgment also take judgment will
interim bail कितने वर्ष रहेगा?
Lords, I am in custody since 10/4/2015.
Oh, 19 such.
And I was taken into custody after I was discharged from SCB Medical College, where I was treated for head injury and for fracture of the CORAM. Exhibit A is the injury.
This is what is the age of the appellant, you said?
Lords, the age of the appellant at the time of delivery of judgment
is 71.
Was 71 years.
So earlier your bail application has
Yes,
not been rejected.
It was rejected 2 years back, my lords.
When?
I have stated, my lords, in the IA, it was rejected on 20th of October 2020.
Oh, achha, all right.
IA number 791 of 2019.
5 witnesses.
Although it is stated that the appellant number 3 is over 70 years old and has spent 8 years in prison, the court is of the view that the better course would be to expedite the out of 5 eyewitnesses, 3 witnesses have named the petitioner appellant.
It's also double murder case.
Yes, it's a double murder case and another injury, my lord. I have been convicted on 302.
It's a double murder case, ma'am. Double murder case, ma'am.
Let him go on interim bail for 3 months. Let us see.
Ma'am.
IN number so and so is an application for bail of appellant number 3, Mr. Devassis Pandaland Counsel for the petitioner submitted that the petitioner is now as it about 75 years. And earlier bail application of the petitioner was rejected on 2010 in IN number 91 of 2019. Though there was a direction for expeditious hearing of the appeal, but there is no chance of early hearing of the appeal in the near future. And therefore, the petitioner bail application may be favorably reconsidered. As per the order dated, order number 10, dated 27/8/2024, the London Council for the State has produced the instruction from the jail medical officer regarding the element of the petitioner, which indicates the swan sweater. Considering the submission made by the London Council for the respective parties, the London Council for the State opposed the prayer for the consider swan. So the age of the petitioner, the element in which he is suffering, the period of detention in judicial custody, and the usual letdown in the case of Letty versus Swan. So 3 months bail granted, and he has to that report from that IAC is to be produced. And
may I pray?
After 3 months, so that he can file the surrender certificate.
May I make a prayer?
Yes.
Can the order be uploaded and the trial court act on the uploaded copy?
All right.
The sons are also in custody.
Order is uploaded every. It will be in the evening hours. It will be up. There is no problem. Yes.
Urgent copy on it.
Yes, sir.
Item 22.
No problem. Lord, that was for whether the appellant has misutilized the liberty or not, Lord, while on interim bail.
Item 22. State has produced the custody certificate. State submitted he may be given some time to obtain instruction as well as so on. Whether there is an early half. କେବେ ଯାଇଥିଲେ ଆପଣ ଆଗରୁ?
That is 19/4/2023.
କେତେ ମାସ ପାଇଁ ଯାଇଥିଲେ?
3 ମାସ ପାଇଁ।
କେତେ ବର୍ଷ ଟୋଟାଲ ରହିଲେଣି?
Lord, custody since 21/9/2016, my Lord. 16, just 8 years.
Murder case?
No, my Lord.
Judgment. Letty versus C.DASH is a decision.
No, that is legitimate. Legit. You are asking for 2 or 1?
2, my lord. Mangal Sai Bhatra and
5 and 6.
yes, my lord. Mangal Sai Bhatra and Maheshwar Majhi.
These both of them have been released on bail
Yes, my lord.
earlier.
Yes.
Temporarily and past insurance to enable all concerns to watch the government shall be convicted. If it will be found that he has issued it as the period of the fail is not be allowed. If however there is nothing within the country, with mails release, he will be disposed of the of course for special reason. So on so the nature of crime, there is a multiple murder, topsides is murder, rape murder, died in daylight, crime, paragraph 2 टा देखिए so and so deceased was returning to his house in a nearby village by means of a cycle. Accused so and so assaulted him by fist blows, slabs, dragged him near the nearby Tenga by means of an axe.
No, incised wound. Incised wound, and that incised.
Axe below the edge.
Yeah, there is something.
Or the learned counsel for the petitioner, learned counsel for the state. Item number 1972 of 2024. So perhaps you have not gone through the decision of the native versus state.
Lord, I have gone through blood, but se agar order thila to se 3 ମାସ ପରେ ବୋଲି କି ସେଥିପାଇଁ
3 months bail is one, so it is produced and it shows that he has not misutilized the liberty. 3 months bail granted. All right.
Item 23.
Next.
Hearing time.
My lord, there is a item 5, my lord.
No, she has started.
No, that's not. Only, my lord, there is a appointment of the advocate, my lord.
Which
item 5, death reference, yes, sir. So, my lord may appoint any amicus curiae or item 5, my lord. A new case, no one is there.
Admission हो जाएगी
किचे इनो
this year let कौन देखियो judgment अटी थी Sanjit Das alias Banku for committing murder of his wife Saraswati Tikli, for attempting to commit murder of his daughter Sri alias Pori. Acha. Accused along with 2 brothers and his widow mother resides in the occurrence house. Just place that paragraph 2.
Paragraph
of the judgment. Just know the fact of the case.
2, my lord.
Paragraph 2. Prosecution case.
My lord, the case of the prosecution that surface on the record is as follows. The accused along with his 2 brothers and his widow mother resides in the occurrence house, which is 3-storied building. There is a family of good repute and affluence. The ground floor is occupied by the younger son Manjit Das,
his family and mother Kanaklata Das. The accused, his wife, the deceased, his 6-year-old daughter Pari, injured victim, and a newborn baby about 3-4 days old reside in the first floor of the building. The eldest brother Ranjit Das and his family live on the top floor. This is Saraswati alias Tikli was working as a head nurse at Sun Hospital, Bhubaneswar. 3 to 4 days before the occurrence, she was blessed with her second daughter. On the date of occurrence, that is on 9/6/2022, Karnaklata Das Pidol 4, the mother of the accused, at about 11 a.m., told her younger daughter-in-law, Sujata Pidol 5, to call the accused to take the food upstairs. Sujata made a phone call to the deceased, but she didn't respond. She then went upstairs and knocked the door, but to no avail. She came down and informed her mother-in-law about the same, who then went upstairs as well. As she was climbing the staircase, she saw the accused coming down. The accused told his mother that he had killed his wife and had slit the throat of his daughter, and saying so, he left the place. The mother of the accused told the pedophile to inform the police. Subsequently, the brother of the deceased, Sasikant Das, Pedophile 6, was informed about the incident. He came, saw the deceased
Dead body.
She saw the dead body and then lost the affair, alleging that the husband and the wife had frequent spat over monetary issues. He narrated in the affair that when he came to the spot, he saw the dead body of his sister lying inside the room, and his niece Pari, whose throat was slit by a sharp knife, had been taken to the hospital.
Okay.
Motive behind the crime is stated to be financial paucity of the accused and the birth of the second girl child.
He is now in which jail?
এটা কোর্টে এইছিলি
এটা হচ্ছে
ভরতপুর প্রেস কেস নাম্বার না ঝাড়খণ্ড
Can you just make a contact to him so that to appear? We want to know that whether he wants to file a regular appeal, number one, or if he is unable to do so, whether he wants that any particular advocate to argue his case as Ramai custody, maybe from Bhubaneswar, maybe from Cuttack, since it's a death reference case. So we are just keeping it as such. Make the contact with that.
So tomorrow we'll make
tomorrow.
Because tomorrow tomorrow.
କାଲି ସେ ଅଛି କଟକ ବେଞ୍ଚ ଆପଣ
ନେକ୍ସଟ ୱିକ୍ ନହେଲେ ଦେଖିବା
ନାଇଁ ଆପଣ କଣ୍ଟାକ୍ଟ କରନ୍ତୁ ପସିବଲ ହବ
ଏବେ
ହଁ ଏବେ
ଆଇ ଟ୍ରାଇଂ
ଝାରପଡା ଜେଲ ଅଛି ଆପଣ
ହଁ ମୁଁ ଦେଖିଲି
ସଞ୍ଜିତ ଦାସ alias ବାବୁ
25 ପିସ୍ କରିଦେଇକି 25 ପିସ୍ କରିଦେଇକି ଆମେ ତ ରଖିବା କାହିଁକି ନେଇପାରେ ଏଇଠି ପ୍ରାଇଭେଟ ଦେଇଥିଲେ କଣ କି ଏଇଠି ଦେଇଥିଲା ସେ ନା ଏଇଟା ପୁରା ଏସଡିସି ଏଇଟା ଏସଡିସି ଥିଲା ଦେଇପାରେ ଯଦି
ଇଚ୍ଛା ପ୍ରକାଶ କରିପାରେ senior advocate let us see them. Contact. Yes, sir.
Peter
Item number 30. Yes.
You were placing yesterday the evidence of PW1.
My lord.
Yeah.
PW2.
Just a minute.
Not I.
You are to place the eyewitness, not the just
1, 3. Then.
Name of the deceased is Sarthak Malik, na?
Sarthak Malik.
There is one injured eye test.
We'll go to that. Deceased.
PW10.
Yes.
TAK Malik. Okay, you come to that PW10. He is an injured eyewitness. So his presence cannot be disputed. That is the settled law. So we have to see that how far what he has stated.
May I go through that?
PW10 person to
See.
Now you can say so.
I know both the accused persons standing in the dock. This is Sarthak Malik is my cousin brother. The occurrence took place about 1 year and 4 months back. On that day, I had gone to the house of my brother Premanand Naik. The village
Of the village.
of the village. There returning, I saw accused Bona
alias
Santosh Malik carrying a thenga was abusing somebody. I tried to snatch the thenga from him, but the accused dealt me a blow by means of the said thenga on my right leg, and I fell down on the ground.
Madam, just watch for a moment. We find that there are two accused who face trial.
Yes.
One is Hemmo Naik, the other is Santosh Malik. Hemmo Naik and Santosh Malik, right?
Yes.
And both the accused were found guilty under section 302 by 34, right?
Madam.
And in addition to that, Santosh is found guilty under 323, and they were acquitted, of course, under 294. And both of them were sentenced to undergo imprisonment for life. That is the judgment passed. So this particular jail criminal appeal has been filed by Hemmo Malik or both the accused?
No, only Hemmo Malik.
Then what about the other one?
Yes, not. As per the report we got, there is no criminal appeal or jail criminal appeal.
How could it be?
Found in the name of accused Santosh Malik or Santosh Naik.
ঠিক আছে এମାନେ ଏଇଠି କଲେ ନାହିଁ ଲିଗାଲ একটা ଅଛି ଲିଗାଲିଟି ଏଇଠି କଣ କଲେ କିଛି କହିବାନି
ଆମେ ସେମିତି ଅର୍ଡର କରିଥିଲୁ କି ଯୋଉ ଭେରିଫାଇ କରିବାକୁ ଏ ଯୋଉ କାହିଁ କିଏ କରିଛି କି ନାହିଁ ନା କଣ ଆପଣ କେମିତି ଆଣିଲେ?
That is from registry.
Oh, registry.
Yes.
This appeal is by so and so. She has been, ଆମେ ତ ଅର୍ଡରଟା କରାହେଇଥିଲା 11/11/2017. The appeal is preferred by Hemmo Naik. He has been convicted along with accused Santosh Malik. It is not known whether said Santosh Malik has preferred an appeal or a jail criminal appeal. Hence, registry is directed to find out if Santosh Naik has preferred an appeal. If the same is still pending, the case so-and-so will it. 2017 ଆପଣଙ୍କୁ କଣ ଆସିଲା instruction?
That is reflected in the.
After verification, there is no CRB so-and-so by accused Santosh Malik or Santosh Naik. नहीं था नाटक संतोष मलिक और नायक को
एलियास ना और
संतोष चिट्ठी लिखा है संतोष मलिक नायक को कैसे
नायक और नायक बोली कर देखिए नोटिंग टा
नोटिंग सी लिखिचंती संतोष मलिक तो लिखा है जो
नहीं तोले पुनी संतोष नायक CRA 134 by 2006 has been filed by Santosh Naik. Santosh Naik. However, on verification, it is found that JCRLA 72 of 2009 has been filed by Santosh Malik and CRLA 2 by 2004 and CRLA 134 of 2006 has been filed by Santosh Naik. Someone named Santosh Naik.
Here is Santosh Malik.
कि संतोष नायक के फाइल करते how he is Santosh Naik consistently achieved. There is no appeal on a jail. Criminal appeal has been filed in the name of co-accused Santosh Malik or Santosh Naik after verification.
ଏଇଟା actually jail authority ଙ୍କ ପାଖରୁ ଖବର ନବା କଥା jail authority ହିଁ କହିଦେବେ ସେମାନଙ୍କର mention ହେଇଥାଏ ସେ ଯୋଉ register ରେ ତାଙ୍କର ଯେ criminal appeal number ବା ଯେ CRL number ସେଟା mention ହେଇଥାଏ registry ତାକୁ ଯେ କୁହାହେଲା registry ତାର ସେ ଦେଖିଦେଲା computer ରୁ ଇଏ କରି ସେଥିରୁ ଜଣା ପଡିବ
ସେଥିପାଇଁ ସେ କହିଲା ଗୋଟେ ନାୟକ ଜଣେ ଫାଇଲ କରିଛି
ଆପଣ ସେ ଇଏ କୋଉ ଜେଲ ଅଛି ବାରିପଦା सर्कल जेल बारिपदा सर्कल जेल बारिपदा ताकू कहले जेल सुपरिटेंडेंट कनेक्शन दबो एटा 2003 मैटर सोडा कौन सा ये 8 जेसीआर में
कंप्यूटर देखिदेव जेते संतोष नायक will unnecessarily be confused. It has nothing to do with Santosh Naik. That could be Santosh Naik. I'm not purposely data. Fifteen, 11, 17. Note.
15, 11. So on so on verification it is found that's it of the announced Santosh Malik. JCRL 72 of 2009.
Santosh Malik Hemo Naik.
It of the last it of the last JCRL 72 of 2009 टा भारत में देखिए कहले की JCRL
this 2004 ये केमती हो 2004 72 2009 नहीं से जो माने जो रजिस्ट्रेशन होता है बाहर कलेक्ट पूरा उल्टा it has nothing
सर्कल जेल बारिपदा रो सुपरिटेंडेंट जेल सुपरिटेंडेंट कहबे मिस्टर त्रिपाठी सर्कल जेल बारिपदा रो जेल सुपरिटेंडेंट कहबे वर्चुअल कोर्ट रे जान डिस्पोज ऑफ इज पेंडिंग डिस्पोज ऑफ इज जजमेंट अपलोड अछि देखि व्यू करो
JCRL 72 is Santosh Malik.
Inform that the appellant Santosh Malik has been
released. So it is disposed of.
No. Who Santosh Malik? That's the picture for them.
And this is a different one. It all. It is tamne se sab guda ko de diya.
ये बहुत पहले और उसके ऊपर हाँ से ऊपर लगी है
ये देखो तो
registry number भी देखो तो 14
no when registry will give the details of every Santosh Malik से बौद्धर कि बलांगीर कि नयागढ़ I would Santosh Naik we have nothing to do
The thing is that once uh, that appeal is pending here, and we decide one appeal to the other, we may give some observation here, so that would not be proper unless we are confirmed that that no, he has not filed any appeal or he is not. He should have filed.
No, the order was passed, but instead of registry, had it been jail superintendent, then probably things would have. ଗୋଟେ order ବି ହେଇଛି ତ 11 11 17 11 11 17 ରେ ଗୋଟେ order ହେଇଛି ସନ୍ତୋଷ ନାୟକ ସନ୍ତୋଷ directly to find out ସନ୍ତୋଷ ନାୟକ ଏକଦମ ଭଲ ହେଇଛି
Market joining. Without joining. ये दी जनक भितर दी accused 1 and 2 भितर किसी तो संपर्क नहीं.
Yes, yes. Accused this petitioner is the father-in-law of that accused.
एज पर जनक लेखा 40 जनक 36 और फादर इन लोग
ଲେଖୁଛନ୍ତି ସେ
यार एज भी जना पड़ुची अपन और ससुर कौन ससुर बयस 40 जोई बयस 36 ना कौन
Which is it?
ସେଠୁ ଲେଖା ହେଇଛି ଏଫଆଇଆର
कौन लिखी पढ़ले
ଆଉ ରିଡିଂ 2002 ଦିବସ ଉପର ଓଳି 4 ଘଣ୍ଟା ସମୟରେ ମୋର ସ୍ୱାମୀ ଘର ପାଖକୁ ଶ୍ରୀ ପ୍ରତାପ ନାୟକ ଘର ଆଡକୁ ଯାଉଥିବା ବେଳେ ଶ୍ରୀ ସନ୍ତୋଷ ମଲ୍ଲିକ ଏବଂ ତାର ଶ୍ୱଶୁର ହେମ ନାୟକ
ତାହେଲେ ଏଜ ମଷ୍ଟ ବି
इसका अच्छा एक्यूज स्टेटमेंट देखिए एज टा एक्यूज स्टेटमेंट लिखा है हेम मल्लिक 40 वर्ष
ये 38 ये 36
36 लिखा है 36
डेट टा बोले इसमें 63
ନା 38
36 38 ଯାହା ବି ହଉ
ବୟସ ପଛରେ ହେଇକି ଲେଖା ହେଇଛି ନା ଜଣେ ଇଏ କଣ ତ ମନୁ ମନ ଲେଖେ ହଁ ସିଏ ଯାହା ବୟସ କହିଛନ୍ତି ଲେଖା ହେଇଛି କେହି କହିଛନ୍ତି ସାକ୍ଷୀ ଯେ ଇଏ ହଉଛି ତାର ଶ୍ୱଶୁର ବୋଲି
ସେଇ ବିଷୟରେ ପକେଇ
ହେମ ନାୟକର ଇୟର ଅଫ ବର୍ଥ ଇଜ 42 ହେଲେ କେତେ ହଉଛି
ଡେଟ୍ ଅଫ ବର୍ଥ
1942 ଦିଆ ହେଇଛି ଫାଇନାଲ ଫର୍ମ
ଟା
82 ହେଇଗଲା
ଆଜ୍ଞା
82
82 ହଉଛି
42 ରେ ଯଦି
ଆଜି ନୁହଁ ଅନ୍ ଦି ଡେଟ୍ ଅଫ ଅକରେନ୍ସ
ତାହେଲେ
ହେମ ନାୟକ ଡେଟ୍ ଇୟର ବର୍ଥ 1942 ଆହୁରି ଅଛି କି କୋଉଟା 42
ସେଇଟା
ଆରଟା 64
ଷାଠିଏ
ହଁ ତାହେଲେ 60 ଆଉ 80 ଠିକ ହେଇଥିବ
60
ତାହେଲେ 60 ଆଉ 80 ଠିକ ହେଇଥିବ
ହଁ ଇଏ ଭୁଲ ସେମାନେ କହିଲେ
received full election
ତାହେଲେ ହେମ ମଲ୍ଲିକ ହେମ ନାୟକ ଯୋଉ କହୁଛନ୍ତି ଠିକ ଅଛି ଏ ଯୋଉ ବୟସ କହି ଲେଖିବାରେ ବା କହିବାରେ ସେମାନେ ଭୁଲ କରୁଛନ୍ତି ହେମ ନାୟକ ହଉଛି ଆର ଶ୍ୱଶୁର ସନ୍ତୋଷର ଶ୍ୱଶୁର
ହଁ କିଏ ଗୋଟେ କହିଛି ବି ଶ୍ୱଶୁର ଜ୍ୱାଇଁ ଇଏ କଲେ ବୋଲି ମାରିକି ଯୋଉ ପଳେଇଲେ ବୋଲି କିଏ ଗୋଟେ କହିଛି
ଜଜମେଣ୍ଟ
ସନ୍ତୋଷ ମଲ୍ଲିକ
Baripada jail, kindly unmute.
ଶୁଣିପାରୁଛନ୍ତି ପଚାରୁ ଶୁଣିପାରୁଛନ୍ତି କି ସେ
Voice ଯାଉଛି ବାରିପଦା jail
ହ୍ୟାଲୋ ସାର୍ ନମସ୍କାର ଶୁଭୁଛି ମ୍ୟାଡାମ
ହଁ ଠିକ ଅଛି ଆପଣ କିଏ କହୁଛନ୍ତି
ମ୍ୟାଡାମ ସାର୍ ମୁଁ ସିନିୟର ସୁପରିଟେଣ୍ଡେଣ୍ଟ ସାର୍ ନମସ୍କାର ମୁଁ ସିନିୟର ସୁପରିଟେଣ୍ଡେଣ୍ଟ S.K. ରାଓ
ଆଚ୍ଛା
ସାର୍
ଇଏ ଆପଣଙ୍କ ଜେଲରେ ଦି ଜଣ ଅଛନ୍ତି କି ହେମ ନାୟକ ଆଉ ସନ୍ତୋଷ ମଲ୍ଲିକ ବୋଲି ଦି ଜଣ ଆଜୀବନ କନଭିକ୍ଟ ଆଜୀବନ କାରାଦଣ୍ଡ ଦିଆଯାଇଛି
ସାର୍ ମୁଁ ଟିକେ ଭେରିଫାଇ କରି ସାଙ୍ଗେ କରୁଛି
ତାଙ୍କ ବୟସ ବି କେତେ ଦେଖିବେ ହେମ ନାୟକ ସନ୍ତୋଷ ମଲ୍ଲିକ
ସାର୍ ସାର୍ ସାର୍
in ST 13/201 of 2002 ଆଉ ଯଦି ଅଛନ୍ତି ତାହେଲେ ତାଙ୍କ ଭିତରୁ ଉଭୟ ଏପିଲ ଫାଇଲ କରିଛନ୍ତି କି ନା ଜଣେ ଫାଇଲ କରିଛି ଆଉ ଜଣେ ଫାଇଲ କରିନାହିଁ
ଏକାଥରେ
ଦେଖିଦିଅନ୍ତୁ
ଆପଣ ରେଜିଷ୍ଟର ଦେଖନ୍ତୁ ହେମ ନାୟକ ସନ୍ତୋଷ ମଲ୍ଲିକ
ସାର୍ ସାର୍
ଦେଖିକି ରିଭର୍ଟ ବ୍ୟାକ୍ କରନ୍ତୁ
ବାରିପଦା ଆଡିସନାଲ ସେସନ ଜଜଙ୍କ କୋର୍ଟରେ ସେ ଟ୍ରାଏଲ ଫେସ୍ କରିଥିଲେ 2003 ମସିହାରେ ଜଜମେଣ୍ଟ ହେଇଥିଲା ଏବଂ ଦି ଜଣ ଯାକୁ ଆଜୀବନ କାରାଦଣ୍ଡ ଦିଆଯାଇଥିଲା ଶ୍ୱଶୁର ଜ୍ୱାଇଁ
ସାର୍ ସାର୍ ସାର୍
ଜଜମେଣ୍ଟ ଡେଟେଡ 23/12/2003
23/12/2003 ସାର୍
23/12/2003 ହେମ ନାୟକ ସନ୍ତୋଷ ମଲ୍ଲିକ
ସାର୍
Will you be back by 15 minutes?
ସାର୍ ସାର୍ ସାର୍
All right.
ଠିକ ଅଛି ଇଏ କରିଦିଅନ୍ତୁ just place କରନ୍ତୁ ଆପଣ PW10 10 ଟା place କରନ୍ତୁ।
I know both the accused persons standing in the dock. This is Sarthak Malik is my cousin brother. The occurrence took place about 1 year and 4 months back. On that day, I had gone to the house of my brother Premananda Naik, of the village. At the time of returning, while returning, I saw accused Bana Santosh Malik carrying a thenga, was abusing somebody. I tried to snatch the thenga from him, but the accused dealt me a blow by means of the said thenga on my right leg, and I fell down on the ground. The accused then dealt 3 blows by means of thenga on deceased Sarthak Malik. My brother also fell down on the ground due to the assault. Accused Hema Naik, who was carrying a budiya, a small axe, rushed to the Sarthak and assaulted him by means of the budiya on his hand. Sarthak sustained bleeding injury and died instantly at the spot. The wife of the deceased, namely Tusi Malik, tried to tender water, but Sarthak did not take the same as he was already dead. One Surendra Malik and Kamali Naik and some others were present at the spot. The accused persons escaped from the spot thereafter. I was examined by the medical officer in Langalapanta Hospital and received treatment. My statement was recorded by the magistrate during the investigation, and I have put my signature therein. This is that statement marked as Exhibit 5 and Exhibit 5.1 is my signature therein. Cross-examination by defense. My house is situated at a distance of about 200 meters from the spot. I am not aware of any dispute or litigation between the deceased and the accused persons. I do not know if Sarthak and the accused persons had consumed handia on the concerned day. I do not know the reason as to why the accused person assaulted the deceased. At the time I heard the halla, I saw them tussling with each other. I found deceased Sarthak and Santosh tussling. Nobody tried to intervene in the assault. Some of the villagers present there started running away from the spot, seeing the assault on the deceased. I lost my sense due to the assault on me. I was taken to the hospital by police on the date of occurrence itself. Accused persons ran away from the spot after the incident. After I lost sense, I do not know what happened thereafter. Paragraph 3. The houses of the accused persons situated very close to the forest. The forest encircled to the village Kendulati and commonly available in that area. I cannot describe the concerned lathi with its number and knots and size. Paragraph 4. It is not a fact that I have not stated before the police that accused Santosh dealt 3 blows by lathi on the deceased and were abusing somebody. Police officer brought me to the court for recording of my statement under section 164 CRPC. I have made statement before the magistrate as per the instruction of the police. It is not a fact that I was not present at the time of occurrence and that I deposed falsely against the accused person, such the deceased is my cousin.
So, any Mr. Tripathi?
Yes.
As it appears, there was some tussle between the two.
Yes.
This deceased Sarthak and Santosh. Anybody has stated that why this tussle arose? Any quarrel between that?
No.
Nobody is dead.
Because if we see yesterday also, she was placing that postmortem report,
Yes.
Which has been proved by PW14. Only 2 injuries are there. One is that incised wound, that is at page 98. That is, of course, attributed against that Budia blow, which was given by Hemo, who is this appellant, of course, in this JCRL. And so far as the Sarthak, who has not preferred appeal, one has also stated that he had dealt number of blows. This Tain has also stated that 3 blows were given by Lathi, but there is only one abrasion on the left side chest.
Yes.
So, what is the why they assaulted? Is there anything? Because so many eyewitnesses are there.
Yes.
They might have seen it from different point of time. So it appears that this PW10, he was he has seen it from the point when that there was tussle.
Yes.
So prior to that, any witnesses?
PW4.
PW4.
Sulochana
Sulochana
Bhukta alias Malik.
May I go through?
I know.
I know the accused Santosh Naik and Hemo Naik. I know the deceased Sarthak Malik. Sarthak Malik is dead.
He was murdered by accused person.
I know the accused Santosh Naik and Hemo Naik. I know the deceased Sarthak Malik. Sarthak Malik is dead as he was murdered by accused persons. The occurrence took place last year on the day of Chatua, that is Pona Sankranti, on one Sunday at 4 p.m.
On that
day, I was standing in front of my house. I saw accused Santosh alias Bona came holding a Kendu Thenga in his hand. He abused in slang language. Sarath came out and challenged the accused Santosh as to why
the latter
abused him in slang language. Accused Santosh assaulted him and gave a blow by means of Kendu Thenga. As one Bharat Naik rushed to intervene, accused Santosh dealt a blow to him by means
Bharat
of
Naik is that PW10.
Yes.
Bharat Naik.
Yes.
Rushed to intervene, accused Santosh dealt a blow to him by means of the said Thenga. Bharat Naik fell down on the ground being assaulted. Accused Santosh again assaulted Sarath by means of this said Thenga. As Sarath fell down on the ground, accused Hema came and dealt a blow on Sarath by means of a kuradi on his head. Sarath died at the spot before we tendered water to him. He could not receive the water. The accused persons ran away from the spot thereafter. They took the weapons in their hands.
So जଣା पड़ुची सी गोटे काहाकु गाली देकिन जाउथला ये तार से घरे थिला बोधे जो डिसीज सी आसी कहला काई तू गाली काल दो दैट इज द सेइथि पई सी बाडी धरथला ताकू पिटिला बोली जहा तार एलिगेशन आछि. Then he fell down and this man came. He assaulted by this Hema. Dealt Kurhadi blow on the head. Eta hochi kotha. Ebong almost all the witnesses have stated that this witness has also stated that number of blows have been given by this Santosh.
Yes.
Even though there is only one abrasion on the chest. So
no provocation.
May I go through cross-examination, Bhanda?
No, is there anything to find out the motive? Oh,
ये जो लाइन टा पूछ
नहीं सी तो ठीक है किंतु हेमन एक तक कहीं बुढ़िया रे मल्ला
से दिजोन जाको जाओ
देखो एक सारे जाऊ थी
से गाड़ी देला को से प्रोटेस्ट करला
से नहीं नहीं ये जस्ट अ मिनट आउ थरे सिचुएशन यू कोडा प्लेस कले कोडा PW4 अच्छा PW4 रो PW4 होची तमने ज्वाई गाड़ी दे दी जाउची ये रही घरे डिसीज सी घर बाहर किना सीम कहला काई तू गाड़ी दउछु सी ताकू गाड़ी दउनी डिसीज को गाड़ी दउनी ये तो कहला काई गाड़ी दउची ये हाथे गोटे कौन केन्दुर ठेंगा धरतला ताकू बाड़ेला बाड़ेला परे PW10 इंटरफियर कला आसिला ताकू गोटे बाहर देइछि तापरे से पड़ीगला डिसीज तले पड़ला सेतिकी बेले ससुर आसिकिनी गोटे चोट देइछि हेड रे कुराड़ी रे ये आउछि केस ससुर ज्वाई but only thing is that this number of blows which is stated to have been given by Santosh, that is there is no medical evidence to that effect. But so far as this other man is concerned, Hemma dealing a blow by means of a kurhadi and the injury which has been caused by that blow and the doctor has found one incised wound size is 7 cm age is 98 2 cm bone deep right side of the skull
সেটা একটা জোরে পকেইছে over vertex right side of skull over vertex.
They have remained in custody since 2003. That means they have must have been for 20 more than 20 years. So whether they are still there or they have been
prematurely
prematurely कारण 2002 रे समाने
he has come back probably. Has he come back?
2002 ମାନେ 22 ବର୍ଷ ଉପରେ 22 ବର୍ଷ କେବେ ଲାଗୁନି ସେମାନେ ଥିଲା ଭଳିଆ
सर नमस्कार
प्रीमैच्योर रिलीज ର ପାୱାର ଯୋଉ ଅଛି ନା 14 ବର୍ଷ ପରେ ତ ସେମାନଙ୍କୁ ରିଲିଜ କରି ଦିଆଯାଏ ସେଇ
They're unmuted probably. Video तो अच्छा है
फोन तो से की से
Yes, senior superintendent is present.
हाँ सर नमस्कार
हाँ
सर ये दी जण अक्यूज सर प्रीमैच्योर रिलीज रे जायछन सर 31/5/2018
देखले प्रीमैच्योर
31/5/2018 सर
अच्छा आउ आरटा
हेम नायक भी जाय सर 31/5/18 दी जण जाको सर सेम डे
ଆମେ ଧରିକି
ससुर जोई सर दी जण
ସେଟା ପଠେଇ ଦେବେ ଆପଣଙ୍କ ପାଖରେ ଅର୍ଡରଟା ଥିବ ନା
सर हमरो लाब्स वारंट हम ऑलरेडी कोर्ट को पठेई दिछु सेही दिन
ପଠେଇ ଦିଅ ତାହେଲେ ତଳ କୋର୍ଟ
मेमो करी कोर्ट सर एडीजे कोर्ट सर दे दिछु बारी
एडीजे कोर्ट ଥିବ that is how we always insist for this yeah unnecessarily we are exercising and
ପରିଶ୍ରମ ଆଜିର ପରିଶ୍ରମ
madam Padi is reading after the matter
ସେଟା କିନ୍ତୁ ଆଣିବାକୁ ପଡିବ ମାନେ ସେଟା एडीजे कोर्ट ରୁ ମଗେଇବାକୁ ପଡିବ ତାକି ଅର୍ଡରଟା ସେ ଆଣନ୍ତି during course of the hearing of the jail criminal appeal when we found that the appellant Hema Malik faced trial along with his father-in-law Santosh Malik in the court of London Additional Session Judge Baripada in ST case number 13/201 of 2002 and found guilty under section 302 of the Indian Penal Code, 302/34 of the Indian Penal Code, and sentenced to imprisonment for life. We wanted to know whether Santosh Malik has preferred any criminal appeal against the judgment and order of conviction or not. Though there was an order passed to that effect on 11/11/2017, directing the registry to find out such aspect, but the information which was supplied by the registry couldn't bring clarification, for which we asked the learned counsel for the state to make the jail superintendent of Circle Jail Baripada to appear through virtual mode. The senior superintendent appeared through virtual mode, and when we made a query to verify the aspect whether the accused Santosh Malik, convict Santosh Malik, has preferred any appeal or not. On verification, he submitted that both Hemo Naik and Santosh Malik have been released, prematurely released with effect from 31/5/2018. Released on 31/5/18 तो
हाँ सर 31/5/2018
31/3 ना 5 है
ना सर 31/5/2018
31/5/2018. Since the document to that effect is not available with the concerned jail superintendent, relating to the order passed by the to release prematurely is not available with the jail superintendent, let a report be called for from the Learned Trial Court, that is Additional Session Judge Baripada, in ST case number so and so, as to whether the convicts Hemo Naik and Santosh Malik have been released prematurely or not, and the copy of the order of premature release shall be sent to this court immediately. The copy of the order be communicated to the Learned Trial Court by the registered judicial through email during course of the day. Matter be listed. I see you next week. Next week, present. We commencing from 17th of September 2024. Yes, anyone else?
Yes. 34 mile.
33 is there. City.
Yes.
33. Yeah.
Because he is languishing in custody more than 15 years.
नंबर भी छोड़ो सर
Please.
असम तो पागल
Madam.
This is a case file again.
Yes, yes. Single appellant, na?
Yes, my lord.
And
The-
302201.
Yes, my lord. Well, the story, the prosecution story is that as per the FIR, my lord.
Please come to the FIR. That
Yes,
is
sir.
at page, it is 32 ନା 30 ରେ ଆରମ୍ଭ ହେଇଛି 32 ରେ
32
ଆପଣ ଏଠି ଟିକେ ଏଠୁ ପଢ ଆମେ ଗୋଟେ ଆରେଞ୍ଜମେଣ୍ଟ କରୁଛୁ ତ ତେଣୁ ଆପଣ ମାନେ ପଢିଲେ ଅଭ୍ୟାସ ହେଇଯିବ।
FIR ଟା କୋଉଠି ଲେଖା ହେଇଛି?
32 ଟା ବାହାର କର।
FIR ଟା
ସେ ଇଏ ଝାରପଡା ଜେଲ ଆସିଲେ କହିବେ ଆଉ।
ଲାଇନ ନେଇ ତ
ନାଇଁ
ହଁ ସେ କନେକ୍ଟ
we are there. There is no problem.
17 ହଁ 17 ମାନେ
ତାଙ୍କୁ କହିଛନ୍ତି ତ ସେ ଆପିରାନ୍ସ କରିବେ ବୋଲି ସେ ଯୋଉ କନଭିକ୍ଟ ହଁ ପ୍ଲିଜ
FIR ଟା ଦେଖେଇ
32 ଟା ବାହାର କଲେ FIR ଟା ଓଡିଆ
ଆଜ୍ଞା
पूरा फुल पेज तो हाँ ठीक है
ଲେଖିବାର କାରଣ ଏହିକି ଯେ
माइक एडजस्ट କରନ୍ତୁ सी कर देबे आप ये
ଲେଖିବାର କାରଣ ଏହିକି ଯେ ମୁଁ ଶଶିକାନ୍ତ ଖାଡିଆ
शशिकांत खाड़िया इज
PW1
ओके
ପିତା ଗଜେନ୍ଦ୍ର ଖାଡିଆ ସୁଖା ଖାଡିଆ ପଡା ଘର ହଉଛି ସୁଖା ଖାଡିଆପଡା ବୟସ 32 ବର୍ଷ ଜିଲ୍ଲା ସୋନପୁର ଅଧିବାସୀ ଅଟେ ଅଦ୍ୟ 17/2/2009 ରାତ୍ରି ମୋର ସ୍ତ୍ରୀ
अच्छा just please wait one accused is there we will interaction there केते नंबर एटा कहले 5 so संजीव दास आमे जहा कहूछु आपण सुनी परचंदी ते तमको अनम्यूट करिया पे
सर अनम्यूट करंतु
के अछंती सेटा अनम्यूट करा हो
ଆପଣ ଏ ପାଖେ ଥାଆନ୍ତୁ କଣ ଦରକାର ପଡିବ
ଆଜ୍ଞା
ତାର ଏଟା ଜଜମେଣ୍ଟ ଟା ଟିକେ ବାହାର କର संजीव दास आपनको जो सेकेंड एडिशनल सेशन जज भुवनेश्वर 18/7/2024 तारीख दिन आपणकर जो स्त्री सरस्वती अलियास टिकिली जो मर्डर करथिले एवं झियो श्री आ परी ताकू मारिदेबा पई जो चेष्टा करथिले सेतपई जो दंड हेची एवं आपनको फांसी आदेश हेची तादिरे आपणकर गोटे जेल रु गोटे अपील आसीची आउ आपण कोनोसी अलगा अपील किछि फाइल करचंती कि ए जो फांसी आदेश विरुद्ध रे
କରିଛି ଆଜ୍ଞା
केते नंबर तार कहि परिबे
ନମ୍ବରଟା ଆଜ୍ଞା ମୁଁ ଜାଣିନି ମୁଁ ତାଙ୍କୁ ନହେଲେ କହିକି କହିବି ସେ ଆପଣଙ୍କୁ ଦେବେ ଆଉ
ନାଇଁ जेल रु पठाइची गोटे अपील जेल नंबर होची 141/2024 तो आपण कोनोसी प्राइवेट वकील को देइकिनी दाखल करैछंती अपील
ପ୍ରାଇଭେଟ ବୋଲି ଆଜ୍ଞା ଦେଇଛି ତାଙ୍କ ନମ୍ବରଟା ଆଜ୍ଞା ମୁଁ ଜାଣିନି
ତାଙ୍କ ନାଁ କହି परिबे प्राइवेट वकील ना
ତାଙ୍କ ନାଁ ଆଜ୍ଞା ନିରଞ୍ଜନ ପଣ୍ଡା
ନିରଞ୍ଜନ ପଣ୍ଡା
ଦେଖିଥିଲେ
କୁଆଡେ ପଳେଇଲା? ଡାକ ଡାକ ଡାକ। ଫାଇଲ କରିବା ପାଇଁ
ଓକିଲନାମା ସାଇନ୍ କରିଦେଇଥିଲି ଆଉ କେବେ ଡେଟ୍ ମନେ ପଡୁନି। 24 ରେ ଗୋଟେ ଲିଗାଲ ସର୍ଭିସେସ୍ ଅଥରିଟି ଗୋଟେ ଦେଇଛି। Legal Services Authority, Submission of Appeal of Convict, numbers 1635A, Sanjit Das alias Banku of Special Judge Bhubaneswar. I am forwarding the appeal petition along with other documents of the condemned prisoner. Number such and such Sanjit Das, now JCRL city ଠାରେ ସେଥିରେ ସରକାରୀ ଓକିଲଙ୍କ ମାଧ୍ୟମରେ appeal ଦିଆହେଲା କେବଳ। ସରକାରୀ ଓକିଲ କିଏ ଦେଲେ? ସରକାରୀ ଓକିଲ କିଏ? legal aid ଦେଲେ। death sentence, second instance sentence, wants to exercise his right of appeal, forwarding Binama and certified copy of trial court. Binama କାହାର ଆସିଛି ପରା ଏଇଥିରେ?
वकालतनामा ଆସିକି ଦେଖିଲ କାଜରେ JCRL ରେ ବିନାମଟା ଯୋଉ ଅଛି କିଛି ନାହିଁ ମାନେ ଅଛି କିନ୍ତୁ ପ୍ଲେନ
ନାଇଁ ନା କାହାରି ନାହିଁ DLS ତରଫ
କିଛି ନାହିଁ ଟୋଟାଲି
OSLS सेक्रेटरी हाईकोर्ट लीगल सर्विसेज कमिटी को दिया है।
ଆପଣ ନିରଞ୍ଜନ ପଣ୍ଡାଙ୍କୁ ଜାଣିଛନ୍ତି ତ?
ଆଜ୍ଞା
ତାଙ୍କର ନମ୍ବର ଆପଣଙ୍କ ପାଖରେ ଅଛି? ଫୋନ ନମ୍ବର
ଆଜ୍ଞା
ଅଛି? ନମ୍ବର କେତେ କହିଲେ?
ନମ୍ବର ଆଜ୍ଞା ମୋର ମନେ ନାହିଁ, ରୁମ ରେ ରହିଯାଇଛି।
ଆଚ୍ଛା ସେ କୋଉ ନିରଞ୍ଜନ ପଣ୍ଡାକୁ ଦେଇଛନ୍ତି? ଅଛି ନିରଞ୍ଜନ ପଣ୍ଡା ନମ୍ବର
ମୋ ପାଖରେ ନାହିଁ।
ଆଚ୍ଛା ଆପଣ ଆମେ ଗୋଟେ କେସ ର ଶୁଣାଣି କରୁଛୁ, ଆପଣ ଯାଇକି ସେ ନମ୍ବରଟା ଆଣିକିନି କୁହନ୍ତୁ ହେଲା, କିଏ ଅଛନ୍ତି ସେ ଆପଣଙ୍କ ପାଖରେ? ସେ ଯୋଉ ଆଡଭୋକେଟ ବାବୁଙ୍କର ନମ୍ବର ଆଣିବେ, ତାକୁ ଆଣିଲା ପରେ ତାଙ୍କୁ ନେଇକିନା ଆସନ୍ତୁ। ସେ କଣ ରୁମ ରେ ରହିଯାଇଛି ବୋଲି କହୁଛନ୍ତି, ନମ୍ବରଟା ନିରଞ୍ଜନ ପଣ୍ଡା ଆଡଭୋକେଟଙ୍କର, ସେ ନମ୍ବରଟା ନେଇକିନା ଆସନ୍ତୁ ହେଲା। ହଉ ଆସିଲେ ଜଏନ କରିବେ, ଆମେ ଅନ୍ୟ କେସ୍ ଶୁଣାଣି କରୁ ହେଲା।
I'm just checking the High Court website there. Employee death offense just got paid up. CRR की फाइल की
नहीं ସିଏ କହୁଛନ୍ତି ଯେ ଓକାଲତନାମା ସାଇନ୍ କରି ତାଙ୍କୁ ଦେଇଛନ୍ତି ତ, ତେଣୁ ଦେଖିଦବା ତାଙ୍କୁ ପଚାରେ ସେଇଠି ଥିଲେ କୁଆଡେ ପଳେଇଲେ। ହଁ ନାଇଁ ସିଏ ଆଣିଥିବେ, ଫାଇଲ କରିନଥିବେ କଣ ରଖିଥିବେ କଣ। ସେ ଯୋଉ ନିରଞ୍ଜନ ପଣ୍ଡା ଯୋଉ ଆସିଥିଲେ ତାଙ୍କର ନମ୍ବର ଅନ୍ୟ କେସ୍ ଥିବ ତାଙ୍କର ମୋବାଇଲରୁ, ଏଇ ଯୋଉ वकालत नंबर ତମକୁ ନମ୍ବରଟା ବାହାର କରୁନାହାନ୍ତି।
ଏଇଠି ଥିଲା ପ୍ରାୟ ତାଙ୍କ କେତେ ନମ୍ବର ଆଇଟମ ଥିଲା ଏବେ? 34 ସେଠି ତ ଥିବ।
ନାଇଁ ନମ୍ବର ଦବା वकालत ନମ୍ବର ଏବେ ନୂଆ ହେଲା ପ୍ରୋଭିଜନ, ସେ ପୁରୁଣା ଆଗରୁ ସବୁ ଦଉନଥିଲା।
ଏଇଟା ବି ନିରଞ୍ଜନ ପଣ୍ଡା ଏବେ ଫ୍ରେଶ ଦେଇଥିବେ ସେ
ନାଇଁ ଖାଲି ଦେଇଛନ୍ତି ଇଏ ନମ୍ବରଟା।
ସନ୍ତୋଷ ନାଇଁ ସାର୍ ଅଛି
ଅଛି କି? ହଁ
88952 ଅଛି ତ?
ସେଇ ନମ୍ବର
ତାପରେ ସାର୍ ନିରଞ୍ଜନ ପଣ୍ଡା 9606 but he is the only lawyer, ତେଣୁ ସେଇ କେସ୍
ତାଙ୍କ ସାଙ୍ଗରେ କଥା ହେଇଯାଆନ୍ତୁ, ଡକେଇ ଦିଅନ୍ତୁ ତାଙ୍କୁ, ଆଉ ଇଆଡେ ବି ସେ ନମ୍ବରଟା ୟୁ ପ୍ରୋସିଡ୍ ଆପଣ FIR ପ୍ଲେସ୍ କରୁଥିଲେ ନା?
17/2/2009 ରାତ୍ରି ମୋ ସ୍ତ୍ରୀ ମତେ ବାହାର ପଟୁ ଶିକୁଳି ଦେଇ ମୋର 2ଟି ଛୁଆଙ୍କୁ ନେଇ କୁଆଡେ ଚାଲିଗଲା। ମୁଁ ଘରର ଅନ୍ୟ ବାଟ ଦେଇ ବାହାରକୁ ଆସି ଦେଖି ଖୋଜାଖୋଜି କଲି, ପାଇଲି ନାହିଁ। ମୁଁ ବଲାଙ୍ଗୀର ଆଡକୁ ଯାଇ ଖୋଜିଲି କିନ୍ତୁ ପାଇଲି ନାହିଁ। ଘରକୁ ଫେରିବା ସମୟରେ ଆମ ଗାଁ ପାଖ ମହାଦେବ କଣ୍ଟା ପାଖରେ
ଖବର ପାଇଲି ଯେ ମୋର ସ୍ତ୍ରୀ ମୋ ଝିଅକୁ ବନ୍ଧର ପାଣି ଭିତରକୁ ତଣ୍ଟି ଚିପି ମାରି ଦେଇଛି ବୋଲି ଶୁଣିଲି ଓ ନିଜ ଆଖିରେ ମଧ୍ୟ ଦେଖିଲି। ମୋର କହିବାର ମୁତାବକ ଠିକ ଲେଖା ହୋଇଥିବାରୁ ମୋର ଟିପ ଚିହ୍ନ ଦେଲି।
Okay.
Then they
Mahadev Montamone for qualification. Big. Okay, then this PW1 is an eyewitness to the occurrence.
No one, there is no one live in this.
କହିଲା ଯେ ମୁଁ ନିଜ ଆଖିରେ ମଧ୍ୟ ଦେଖିଲି
ଭାସିଲା।
ଡେଡ୍ ବଡି ଟାକୁ ଦେଖି
Can you read the invitation of
ଦେଇଛି ବୋଲି ଶୁଣିଲି ନିଜ ଆଖିରେ ମଧ୍ୟ ଦେଖିଲି।
ଆଚ୍ଛା ଆପଣ
I am the informant in this case.
No, you please come to page number 36 charge ଟା press କରନ୍ତୁ ତାପରେ ଯିବେ PW1।
ଆଚ୍ଛା ଆଚ୍ଛା
36 ପୃଷ୍ଠାକୁ ପଳେଇ ଆସନ୍ତୁ।
ଆଗ ଫାଷ୍ଟ ପେଜ ଟାକୁ
ହଁ ଫାଷ୍ଟ ଟା ପଢନ୍ତୁ। ଦିଟା ଚାର୍ଜ ଫ୍ରେମ୍ ହେଇଛି ପେଜ 36 ଚାର୍ଜ ଟାକୁ କ୍ଲିକ୍ କରିଦିଅନ୍ତୁ ଖୋଲିଯିବ।
I, Sri S.K. LLB, additional first that on 17 to 2009 in the night you had left the house of your husband, namely Sachikanta Khadia. I located in Khandiapada under Dungaripalli with your two daughters, namely Nabina, aged about 3 years, and Karina, aged about 2 years. Without the knowledge of your husband, that in that night you had killed your youngest child, namely Karina, by strangulating her neck by your fingers, causing asphyxia near a pond locally known as Rugudikota, located near Mahadev Temple of village Khadiapada, Sukha, and that you thereby committed an offense punishable under section 302 of IPC and within my cognizance. Secondly, that you on 17 to 2009 in the midnight near Mahadev Temple of village Khadiapada, Sukha, you had thrown the dead body of your youngest child named Karina after killing her by strangulating her neck by means of your fingers with intention to make disappearance of all evidence and relevant materials in support of the murder of late Karina by you using or adopting the above method, that you thereby committed an offense punishable under section 201 of IPC and within my cognizance. And I thereby direct you that you be tried on the said charges.
Okay, now you come to PW1.
PW1.
By the way, you come to the last question put to you in the accused statement, page 40.
42. 42 ଟା click କରିବି।
ସେ ପଢି ଯାଉଛି
42 ଟା click କରିବି page
accused statement ଗୋଟେ heading ଥିବ statement of the accused alias
heading of the deposition of PW1
ସେଇ
second
page 42 କୁ ଆସ
42
question number ହଉଛି 25 statement of accused person ଲେଖା ହେଇଛି ତା ତଳେ ଲେଖା ହେଇଛି ବୁଡୁଲି alias ହେମ ଖାଡିଆ
42 ତ କାଇଁ ନାହିଁ
37 ଦେଖିଲେ
43 ଅଛି
ଆଚ୍ଛା statement of accused ନାହିଁ ତା ଦେହରେ ଯୋଉଠି ଦେଖୁଛୁ
form of recording examination
form of heading of deposition of PW1
ନା
ଠିକ ତା ପୂର୍ବରୁ page
final form
ନା form of recording examination of accused examination of accused
form of recording examination of
form of recording examination of accused
accused এটা এটা ସବୁଥିରେ ହଁ ମାଛି it transfers
come to page question number 23 first
23
क्वेश्चन नंबर 23 और 25 को आसो।
It transfer from the evidence of PW3 that on the basis of the above scratches at her neck, he had come to the conclusion that the death of Chuanani was due to asphyxia as a result of throttling of her neck, and that he had prepared one report about his above opinion as per Exhibit 1. That do you say? What do you say? ମୁଁ ତଣ୍ଟି ଚିପି ମାରି ଝିଅକୁ ପାଣିକୁ ଫୋପାଡ଼ି ଦେଇଥିଲି।
Now we come to question number 25.
Have you got to say anything more about this case? ସେଦିନ ମୋର ମନ ଭଲ ନଥିଲା। ରାତିରୁ ଉଠି ଦୁଇଟି ଯାକ ଝିଅଙ୍କୁ ସାଙ୍ଗରେ ନେଇଗଲି ମହାଦେବଙ୍କ ବନ୍ଧ ପାଖକୁ। ସାନ ଝିଅକୁ ତଣ୍ଟି ଚିପି ମାରିଦେଲି ଓ ବନ୍ଧ ପାଣିରେ ଫୋପାଡ଼ି ଦେଲି। ମୁଁ ଦୋଷ କରିଛି, ସାକ୍ଷ୍ୟ ଦେବି। କ୍ଷମା ଖାଡ଼ିଆ।
Now you come to the PW1.
PW1, the husband of the accused. I am the
problem.
Mr. Panda has come.
Sir. Mr. Panda, please come. There is a death reference listed before our court.
Sir.
That is item number 5. And the convict is one Sanjit Das. It's a Bhubaneswar case.
Sir.
We made a query to him whether he has engaged any counsel. He said that I have given the V-Nama to Niranjan Panda. Of course, he has not stated who is that Niranjan Panda. So whether any such client has handed over you any
I have to check off. Because there are many transfer briefs are
no, it's not
not transfer directly.
July masare फांसी ହେଇଛି ଆକୁ
no
ଏମିତି କିଛି କେସ୍ ପାଇନାହାନ୍ତି
no certain matter
କାରଣ ଫାঁସି କେସ୍ ରେ ଆପଣ वकालत नामा ପାଇ ଚୁପଚାପ ଘରେ ବସିଯିବେ
ନା ମୁଁ ପାଇନି ସାର୍ ସେଭଳି କେହି ପାଇନି ପାଇଥିଲେ
ଆମେ ବାର୍ କାଉନ୍ସିଲ କୁ ଲେଖିଥା
ମୁଁ ଚିହ୍ନିଛି ତାଙ୍କୁ ଆଉ ଅନ୍ୟ ନିରଞ୍ଜନ ପଡେ କିଛି
ସୋ ଠିକ ଅଛି ତାହେଲେ ସେ କୁହନ୍ତୁ ସେ ନମ୍ବର କୁହନ୍ତୁ ଆପଣ ଟିକେ ବସିଥାନ୍ତୁ କାରଣ ସେ କାହାକୁ ଦେଇଛନ୍ତି ସେ ଯାଇଛନ୍ତି ନମ୍ବରଟା ଆଣିବା ପାଇଁ
ଆମେ ଆପଣ ଛବି ଦେଖେଇବୁ
Please wait. Yes, please press PW1.
I am the informant of this case. I know the accused standing in the dock who happens to be my wife. About 9 to 10 years back, I had married her. We both had been blessed with one son and 2 daughters. About 1 year back, my youngest daughter named Karina has breathed her last. About 1 year back, one day in the night, in one rooms of our house, I and my son were sleeping on a cot, whereas the accused and my 2 daughters were sleeping on another cot in that room. At about 3 a.m., when I woke up, I found my wife and 2 daughters absent in that room. I searched hither and thither and could not trace them. On the next day of incident, I found the dead body of my youngest daughter, Karina, floating inside a pond located near Mahadev temple. Then I reported to the police. Cross-examination. My parents are alive, and so also my elder brother and my wife and his wife. I and my elder brother were living in one campus with our families. The room in which I and my wife with children were sleeping had a door. It is a fact that my wife was observed to have mental retardedness prior to the alleged incident and also as on the date of incident. It is a fact that I had not seen as to who had taken my youngest daughter from inside my house in the night of the incident. I had informed to my paternal uncles, namely Raghu Khadia and Phaggu Khadia and Ganesh Khadia, about the missing of my daughter, and then I had proceeded to Bolangir on searching. I had not informed to any other villagers about such incident. It is not a fact that I have foisted this case against my wife with an aim to drive her out of my house forever.
Okay, go on reading one by one. No, two questions.
Okay.
Atrata Sakina Samuday?
Yes.
Yes, one by one.
Second, Hoggo Khadia, brother of the informant. The accused happens to be the wife of one Sasi Khadia, and Sasi Khadia happens to be the son of my elder brother, named Gajendra. Ye dada. About more than 1 year back, one day in the morning, I had been to plow the lands of one Daharu Khadia. I had at that time that the accused had murdered her youngest child. I returned to my house. I further had that the dead body of the female child of the accused was floating on the village pond, whereas the accused was sitting nearby the embankment. I rushed to the spot and found the dead body of the female child floating on the water of the pond, whereas the accused was sitting on the nearby reeds on the said pond. The said village pond was located near the Mahadev temple. I had seen the police coming to the spot and recovering the dead body. I know nothing more about this. Man, in the cross examination, he said that I have got my house nearby the house of the informant Ganesh Khadia. Informant Ganesh Khadia is my elder brother. It is a fact that by the time of my arrival at the reach of the village pond, where the dead body of the female child was floating, Ganesh Khadia, Tikkelal Putel, and others had already gathered there. At that time, the informant was not there. Here said that he is sitting on the ridge of the embankment, but here he is saying that where the dead body was female child was floating. Ganesh Khadia and
Who said that informant was there at the spot?
Well, this is
the examination. He stated that the appellant was sitting.
Appellant was sitting in the embankment, and the
informant.
Not
yes,
the informant.
Yes, will get taken.
The appellant, I rushed to the spot, found the dead body of the female child floating on the water of the pond, whereas the accused was sitting nearby the said pond.
She was sitting.
Yes, my lord. Located near village Mahadev temple. But in the cross-examination, he said that it is fact that by the time of my arrival on the ridge of the village pond, where the dead body of the female child was floating, Ganesh Khadia, Tikkelal Putel, and others had already gathered there. At that time, the informant was not there on the spot.
So it is not about informant.
It is a fact that before I had seen the dead body in the village pond, I was not informed by the informant about the incident.
Yes.
It is a fact that I have not stated before the IO during investigation that I had seen the accused sitting on the ridge of the village pond.
Okay.
Near the water where the dead body of her female child was floating.
Okay. Please take your seat. Mr. Panda, please start. Say,
Sanjeev. Subhuti, Sanjeev Das.
Yes, he got the
party କରୁଛନ୍ତି
संजीव दास से नंबर आनले कि जो एडवोकेट को नंबर
आज्ञा
नंबर टा पढ़िले केते नंबर
सर पढ़छि 78
46
85
केते कोन
85
84
85
65 85
କିଏ ଧରିଛନ୍ତି ଆପଣ ଟିକେ ରିପିଟ୍ କଲେ ପୋଲିସ ପର୍ସନାଲ କିଏ ଅଛନ୍ତି ରିପିଟ୍ କରନ୍ତୁ ପୋଲିସ ପର୍ସନାଲ ହଁ
Sir, 78
ହଁ
46 85 84 85.
ନା କଣ ଲେଖା ହେଇଛି ଆଡଭୋକେଟ ନା
Sir, Niranjan Panda.
এটা আপনার নম্বর
No, no,
ঠিক
this is
আছে
not.
বলে আচ্ছা এটা
କନଫର୍ମ କଲା ପରେ କନଫର୍ମ କଲା ପରେ
ଆମେ ଦେଖିବା ଏଟାକୁ ନେକ୍ସଟ ୱିକ୍ ନବା ଆପଣ ଟିକେ କଣ୍ଟାକ୍ଟ କରନ୍ତୁ ଆଚ୍ଛା ଏଇ ମ୍ୟାଟର ଆସନ୍ତା ସପ୍ତାହରେ ଆମେ ଦେଖିବା ଆପଣଙ୍କର ଓକିଲ ବାବୁ ଫାଇଲ କରିଛନ୍ତି କି ନାହିଁ ଆମେ ଦେଖିକିନି ଆପଣଙ୍କୁ ପୁଣି ଆଉ ଥରେ ଆପିୟରାନ୍ସ ପାଇଁ କହିବୁ ଆଉ ଆପଣ ଆଉ ଗୋଟେ କଥା ମନରେ ସ୍ଥିର କରନ୍ତୁ ଯଦି କୌଣସି ଆଡଭୋକେଟ ସିନିୟର ଆଡଭୋକେଟଙ୍କର ନାଁ ଜାଣିଥିବେ ଆପଣଙ୍କର ଇଚ୍ଛା ଥିବ ଯେ ସିଏ ଆପଣଙ୍କର କେସ୍ ଟାକୁ ହାଇକୋର୍ଟରେ ଆର୍ଗୁମେଣ୍ଟ କରନ୍ତୁ ଆପଣଙ୍କ ପାଇଁ ତାହେଲେ ଆମେ ଆପଣ ଯଦି ଆମକୁ ନାଁ ଦେବେ ମଧ୍ୟ ଆମେ ସେ ଆଡଭୋକେଟକୁ କହିବୁ ସେ ଆର୍ଗୁମେଣ୍ଟ କରିବେ ବୋଲି କାରଣ ଏଟା ଫାଶୀ କେସଟା ତେଣୁ ଆପଣ ମନ ସ୍ଥିର କରି ରଖନ୍ତୁ ଆମେ ଆସନ୍ତା ସପ୍ତାହରେ ଯେତେବେଳେ 17 ତାରିଖ ଦିନ ଯେତେବେଳେ ମ୍ୟାଟର ଟେକ୍ ଅଫ୍ ହବ ଆମେ ଆପଣଙ୍କୁ ପୁଣି ଆଉ ଥରେ ସେଦିନ ଇଏ କରି ଯାହାକୁ ଆପଣ ସ୍ଥିର କରନ୍ତୁ ବୁଝାବୁଝି କରନ୍ତୁ ଆଡଭୋକେଟଙ୍କ ବିଷୟରେ ହେଲା ଭୁବନେଶ୍ୱର ହଉ କଟକ ହଉ ବା ଅନ୍ୟ କୌଣସି ଇଏର ଯଦି ଭଲ ଆଡଭୋକେଟ ଆପଣ କାହାକୁ ଚାହୁଁଛନ୍ତି ଆର୍ଗୁମେଣ୍ଟ କରିବାକୁ ତାହେଲେ କହିଲେ ସେ ଆମେ କହିବୁ ତାଙ୍କୁ ହେଲା ଠିକ ସେଟାକୁ ସେ ଯୋଉ ଅର୍ଡରଟା ଲେଖା ହେଇଥିଲା ଯୋଉ କିଏ ନେଇଥିଲା ଡିକ୍ଟେସନ ଏଟା କି ଅର୍ଡର ପାସ୍ ହେଇଥିଲା କି ନାଇଁ ଠିକ ଅଛି ତାହେଲେ ଏଟା ଖାଲି ରହୁନା ତାକୁ ଠିକ ଅଛି କଣ୍ଟାକ୍ଟ କରିବାକୁ କହିବେ ତାଙ୍କୁ ବୁଝିବେ ୟେସ୍ ମିସ୍
ଇଏ କରନ୍ତୁ ନାଇଁ ନାଇଁ
କାଟିଦେବାକୁ କହିବେ କାଟି Please start. Upon PW ପଢିଲେ
Okay. The accused happens to be the wife of one Shashi Khadia, and Shashi Khadia happens to be the son of my elder brother named Gajendra. About more than 1 year. ତାର cross examination ଟା ପଡେ
ସରିଲା ପରା
ସରିଲା
now you come to PW3
ଡକ୍ଟର PM ଡକ୍ଟର
Anant Kumar Behra. Doctor, on 19 to 2009, I was working as O&G specialist in the HSC Binka in the district of Subarnapur. On that day, about 11:50 a.m., I had received the dead body of the Chuanani along with requisition of both police of PS and Dungripalli in the above district to conduct postmortem examination. Chuanani was the daughter of one.
ଛୁଆ ନନି କହନ୍ତି ନନି ମାନେ ଝିଅ ଛୁଆ ମାନେ ଛୋଟ ଛୋଟ ଝିଅର
Chuanani was the daughter of Sasikanta Khadia of village Sukha Khadiapada under PS Dungripalli. Chuanani was found aged about 2 years as on the date of her death. During conduct of postmortem examination, I found 4 numbers of scratches at the right side on the neck of the dead body. I had not found any internal injury in the dead body. Observing the above marks of injury, I came to conclusion that the death of Chuanani was due to asphyxia as a result of throttling of her neck. This is my report and this is my signature thereon. The same was marked as Exhibit 1 and 1 by 1 respectively. The scratches were antemortem in nature and found caused by human nails. The death appeared to have been probably caused within 34 hours back at the time of my cross-examination. I ascertained the parentage of the deceased from his from the contents of the requisition sent by the police. I had not marked any mark of injury on the left side of the neck of the dead body. The thyroid gland was found intact along with cartilage. I have not mentioned that the injury found at the neck of the dead body were antemortem. Here he said the antemortem, here he said not antemortem. And I have opined the hours of death observing the change of color of the dead body, but I have not mentioned this same in Exhibit 1. I cannot say the color of the dead body when I had received the same from the police. It is not a fact that dead body was not of the daughter of Sasikanta Khadia and named Chuanani, and that without conducting any postmortem examination, I have furnished a fabricated postmortem report being influenced by the police.
Next.
Next is Kamojo Rana, Chandra Rao.
Yes. He has collected
nail clipping.
Nail clipping. On 19 to 2009, I was working as O&G specialist in CSC Dunguripalli in the district of Subarnapur. On that day on police requisition, I had collected the nail clippings of all fingers and toes of the accused of this case who had brought to the CHC by the police. After such collection, I had kept the same in plastic under seal. I had affixed mark of my seal on the paper attached to it. Thereafter, I had handed over the same to the police. This is the letter in original address to the IO while sending the nail clipping of the accused kept in a sealed box. This is my signature thereon. These are marked Exhibit 2 and 2/1 respectively. Cross-examination. Accused was a stranger to me prior to collection of her nail clipping. All the nail clipping were collected by clipping. I had signed on the seal of the box before handing over to the police.
Nail clipping, of course, there is no blood. Page 62 is that report.
It is not a fact that I have collected the nail clipping.
63 is important.
62 na 62 report. Okay, you come
No,
to
no blood, but 63. No, it was only scratches. No, there was no bleeding then.
Yes, sir. Yes, sir. Even now you come to PW5.
5. I know the informant namely Sasikanta Khadia and his wife namely Hema Khadia. Hema and Sasi were blessed with three female children. About 1.5 years back, one died at about 11 a.m. But he has one son, two daughters. About 1.5 years back, one day at about 11 a.m., hearing rumor that the youngest child of the accused had breathed her last by drowning in the water of Rugudi Bandha, alias Mahadev Khota. Khota. I had been to the spot and found that the dead body of that child was floating in the water and at that pond, and the accused was found sitting on the embankment near the floating and dead body. There was a gathering of 60 to 70% at the spot. I saw the elder daughter of the accused was present near the accused and that place and thereon being asked by some villagers that elder child of the accused was heard saying to them that the accused had murdered her younger sister by drowning in the water of the pond. After half an hour of my arrival, the police had come to the spot, recovering the dead body of the child from inside the water and inquested the same. I had signed the inquest report prepared by them then and there. This is the inquest report and this my signature thereon. These are marked Exhibit 3 and 3/1 respectively. The then age of the elder child was within 3 to 4 years. Cross-examination, my lord. In the year 1995, because of the factionalism in our village, police had to camp in our village to maintain law and order. It is a fact that I am the informant of the criminal case relating to murder of my father, and I have already deposed in this court as a witness. By the time of my arrival to at the spot, there was a gathering of 40 to 50 person there at the spot. One Uddhava Pandey of our village was heard asking the elder child of the accused about the cause of death of her young child. I have been examined by the police on the same day. It is a fact that I have not stated the police during investigation that I had the child of the accused replying the same villager that her mother had murdered her younger sister by throwing her in the water of pond. Here he refused to say that he has not said. Seen this youngest daughter was saying that her mother has murdered that younger girl. As I was asked by the police about this above particular facts, I had not stated so during investigation. And it is not a fact that I have stated before the police that I had heard from the villager about the death of the youngest child of the accused. I cannot say the number of the cases instituted against me in the court of Rampur and Sonpur. It is not a fact that I am deposing falsehood against the accused, as I have previous enmity with her due to village factionalism. He is contradicting.
6 PW6 question.
6. I know the accused standing in the dock, but I am afraid. And do not know perhaps his name. About 1.5 years back, at about 1:30 p.m., I was returning from Dunguripalli. I saw on the way of return by huge gathering on the embankment of Mahadev Khata, a pond of our village. I went to the place and found the accused sitting with a female child, then aged about 3-4 years. I heard from the people gathered there that the accused had murdered her youngest child. On inquiry, I found the dead body of that female child floating in the water amidst Amori bush. The dead body of that female child was facing downward. I informed the police of PS Dungurpalli about the above incident over the mobile phone. Cross-examination. I had no acquaintance with the accused of this case prior to the alleged incident. I had not inquired about the parentage of the name of the husband on the above date. I cannot say the name of the person who had told me that the accused had murdered her eldest child. It is not a fact that I had neither been to the spot nor seen any dead child, nor had anything, and that I am deposing falsehood.
So let us come to the what we found. The other witness we of course will go. Your husband stated that in that date of occurrence, he was sleeping with the son. Right?
In one court.
In one court. In another court, you were there,
with
and
the
two daughters were there. And when he got off, he found that you were not there, neither those two daughters. This is one piece of evidence, circumstantial evidence, case. Second,
and it was locked from outside. From outside.
The room was locked from outside. Next is you were found near a pond, and the other daughter, that daughter was also with you, was surviving, of course. And the dead body of the deceased, that is your youngest child, that was found in that pond. And when the postmortem was conducted, it was found that it is a case of strangulation. And
But 2-3 person have already said that in their cross-examination that they have not seen the accused near the embankment, the ridge of the embankment.
no, we are coming to that admission part in the accused statement. So, because if there is no evidence merely because the accused stated something in the accused statement, that cannot be a ground, but it can be said additionally taken into account. So we will see that how far prosecution has proved its case, and then what is your reply in that accused statement. So one, your presence with the deceased, then you leaving the house without intimating your husband, locking the door from outside, locking that room was locked from outside, then your presence at the spot. That spot means that pond, and with one of the daughter, and the other daughter is in that pond, and this cause of death is. You have not offered any explanation. Rather, you have admitted all these things that yes, I have left, I have killed, I have all these things, and the ଯାହା ଆପଣ accused statement ରେ କହିଛନ୍ତି, that is also getting corroboration from the medical evidence. That the PM doctor also says that it's a case of strangulation, and so how do you say that that yes, the prosecution has not established its case, and even though it's a case based on circumstantial evidence, of course, in the FIR it is stated that he had seen, but that part is not there in the evidence. PW1's evidence only. ମୁଁ ଦେଖିଥିଲି ମାରିଦେଲା ବେଳେ ସେ part ଯଦିଓ ନାହିଁ, ବାକି ଏଇ ଯୋଉ circumstance ରହିଛି, ଆପଣ
ସେ ଦେଖିନଥିଲେ, ସେ କହିଲା ମୁଁ ବସି ଦେଖିଲି ତାକୁ ସେ ନଦୀରେ ପୋଖରୀ ପାଖରେ ଥିଲା।
ମୁଁ ଖବର ପାଇଲି।
ଖବର ପାଇଲି।
not only PW1, maybe
ଅନ୍ୟ ଯୋଉମାନେ କହିଛନ୍ତି କ୍ରସ ଏକ୍ସାମିନେସନ ମନା କରିଛନ୍ତି, ଆମେ ତାକୁ ଦେଖିନୁ, ଆମେ କହିନୁ ସେମିତି, ସବୁ କଣ୍ଟ୍ରାଡିକ୍ଟ କରିଛନ୍ତି।
No, let us come to them. PW1
ଆଜ୍ଞା
ଏଇ ଆସ୍ପେକ୍ଟ ଟାକୁ ଆସନ୍ତୁ ଆପଣ। ଯୋଉ ଆପଣ ପୋଖରୀ ପାଖରେ ଥିଲେ, ଗୋଟେ ଝିଅକୁ ଧରିଥିଲେ, ଆଉ ଗୋଟେ ଝିଅର ଡେଡ୍ ବଡି ମିଳିଲା ପୋଖରୀରୁ, ଏଇ ଆସ୍ପେକ୍ଟ ଉପରେ you come to PW1. Let us come to that part.
Yes, Pali.
ଆପଣଙ୍କର page number 43 ର chief examination ର last 3 line ଦେଖନ୍ତୁ। On the next day of incident, ସେଇଠି ପଳେଇ ଆସନ୍ତୁ।
At about 3.
ନାଇଁ, on the next day. ତଳକୁ ଆଉ ତଳକୁ।
I found dead body of the youngest daughter, Karina, floating inside a pond located near Mahadev temple. Then I reported to the police.
Okay, of course, he has not stated about your presence at the spot pond, right?
Yes, my lord.
And he has stated about the mental badness.
ଆଗରୁ ଥିଲା, ଏବେ ବି ସେତେବେଳେ ବି ଥିଲା।
So a witness PW1 with the informant in the case, though of course he is your husband, and he has not stated about your presence at the spot. What about the other witnesses who have stated? 80 পড়ে আসুন, PW2 को পড়ে আসুন।
I rushed to the spot and found the dead body of the female child floating on the water of the pond, whereas the accused was sitting on the nearby ridge of the said pond. And this said village pond was located near Madhav temple. In the cross-examination, it is a fact that I had not stated that before the investigation that I had seen the accused sitting in the ridge of the village pond near the water where the dead body of her female child was floating.
Not to have stated.
Yes, ma'am.
Okay, then
Other doctor.
PW3.
Doctor.
Doctor, leave it. Come to PW4.
4.
The doctor.
Doctor.
I gave you
PW5.
doctor. I
had been to this spot and found that the dead body of the child was floating in the water at that pond, and the accused was found sitting on the embankment.
Near the plugging. There was gathering of 60 to 70% at the spot. I saw the elder daughter of the accused was present near the accused at that place. Thereon being asked by the same villagers that elder child of the accused was heard saying to them that the accused had murdered her younger sister.
Not believable.
18.
No, it's just this contradiction part which has been put in paragraph number 6.
Yes.
That has been proved through the IO. You come to page number 57. Please come to page 57, paragraph 5.
52, 57.
PW8.
57.
57 of cross-examination, paragraph 5.
Paragraph 5. I had examined PW5 during the investigation of the case. It is a fact that PW5 was not stated before me that he had heard one of these daughters of the accused telling the villager that at that place that her mother had murdered the deceased by throttling her in the water of the tank. It is a fact that PW5 has stated before me that he had learned from the villagers that one of the daughters of the accused was telling them that her mother was the author of the murder of the deceased. The written report lodged by the informant was not scribed in my presence. I had not seen the accused while receiving the affair. I had not seen the accused receiving the affair. It is a fact that when I reached the spot,
so that means let us say PW5 ର evidence ରୁ ଆସୁଛି ଯେ ଯେତେବେଳେ ଇଏ ପହଞ୍ଚିଲା ସେତେବେଳେ ବହୁତ ଲୋକ ବି ଥିଲେ ତା ସହିତ ଆପଣ ବି ସେଠି ବସିଥିଲେ ଯୋଉ ଝିଅ ସହିତ
ପଛରେ ମନା କରିଛି କ୍ରସ୍ ଏକ୍ସାମିନେସନ ମନା କରିଛି ସେ ବି
PW5
ଆଜ୍ଞା
କଣ ମନା ହେଲା
cross examination of fine. And,
I had been to this pond, found that the dead body of the child was floating, and accused was found sitting on the embankment near the floating by the floating of the dead body.
By the time of my arrival,
60 to 70%. 60-70 ଲୋକ ସେ ଜାଗାରେ ଥିଲେ
ତାପରେ ଏଠି 40 ରୁ 50 ଜଣ
ଆପେଲାଣ୍ଟ ବସିଥିଲା ଆପେଲାଣ୍ଟ ପାଖରେ ଆଉ ତା ଝିଅଟିଏ ମଧ୍ୟ ଥିଲା ସେତେବେଳେ ଡେଡ ବଡିଟା ତାର ଯୋଉ ଡିସିଜ ର ଡେଡ ବଡି ସେ ଫ୍ଲୋଟ କରୁଥିଲା ସେ ଯୋଉ ପାଣିରେ ଏହା ହଉଛି ତାର ଚିଫ ଏକ୍ସାମିନେସନ
ଆଜ୍ଞା
ବାକି ଅନ୍ୟ ଯୋଉ ସେ ଝିଅ କହିଲା ତାର
କ୍ରସ୍ ଏକ୍ସାମିନେସନ ରେ by the time of my arrival at the spot there was gathering 40 to 50
ଅଛି ଚିଫ ରେ ବି ତ ଅଛି
ହଁ ସେ 60-70 କଲେ ଏଠି କଲେ 40
that is not contradiction.
And one Uddhava Pandya of our village was hard asking the elder child of the accused about the cause of the death of her child.
Presence ଟା ଆପଣଙ୍କର ରହୁଛି ସେଠି ସ୍ପଟ ରେ ଅନ୍ୟମାନେ ବି ଥିଲେ
I have not stated the police during investigation that I had heard the elder child of the accused replying the same villager that her mother had murdered her youngest sister.
Okay, now you come to PW6. PW6 कौन बोला? I went to that place and found the accused sitting with the female child aged about 3 to 4 years. I heard from the people gathered there that the accused had murdered. I said, people go to inquiry. The dead body of the female child was facing so.
I found gathering 15 to 20% of that village spot. I further ascertained that the father of the deceased girl has been outside the village on searching the deceased and her mother. Then I arranged to guard the dead body. The staff who had accompanied, and then when the father of the accused reached at the spot at about 4:30 p.m., He, after obtaining one written report being scribed by one Kailash Chandra Satpathy as per his statement, handed over the same to me.
FIR ଥିଲା ନା ସେ କବାଟ ବନ୍ଦ କଥାଟା ଇଏ କହିଲେ
FIR ଥିଲା.
that is not
ATI, this is
right,
the report,
Peter
this is my signature.
FIR.
I visited the spot, recovered the dead body of the deceased and made inquest. I
He is the
had prepared the
informant, but
inquest
he is not
report.
saying about it.
That I exhibited.
ସେ ଏଇଠି ବରଂ କହିଦେଲା ଯେ
I had examined the
ନାଇଁ ନାଇଁ FIR ନାଇଁ PW1 statement.
କାଇଁ
Really?
About 1 year back, one day in the night, in one of the rooms of our house, I and my son were sleeping on a cot, whereas the accused and my two daughters were sleeping on another cot in that room. At about 3 a.m., when I woke up, I found my wife and my two daughters absent in that room. I searched hither and thither and could not trace them. On the next day, I sky.
It is the fact that I had not seen that who had taken my youngest daughter from inside my house in the night of the incident. किए नहीं गले ताको उठेकी से जान लेनी.
No, it's all right. That's
तापे छुआ मानु छोट छोट छुआ को उठेला बार तो से ता कांदी देबे.
Mr. Tripathi,
yes, ma'am.
ଆପଣଙ୍କର ଏଭିଡେନ୍ସ ତାହେଲେ ସେ ଆକ୍ୟୁଜ ଷ୍ଟେଟମେଣ୍ଟ କୁ ପଛରେ ରଖନ୍ତୁ, ଆଗେ ଆପଣ ପ୍ରସିକ୍ୟୁସନ କଣ ଆଣିଛି ଆମେ ଦେଖିବା। ତ PW1 ଏଭିଡେନ୍ସ ଅନୁଯାୟୀ ଏମାନେ ଦି ଜଣ ଦିଟା ଝିଅ ସହିତ ଇଏ ଗୋଟେ ଖଟରେ ଶୋଇଥିଲା ଘଟଣା ଦିନ ରାତିରେ ହେଲା। ତାପରେ ଯେତେବେଳେ PW1 ଉଠିଲା ଦେଖିଲା ଯେ ସେ ଦିଟା ଝିଅ ବି ନାହାନ୍ତି ଆଉ ଇଏ ବି ନାହିଁ, ଇଏ ହେଲା ଗୋଟିଏ ଏଭିଡେନ୍ସ ଆପଣଙ୍କର। ଆପଣଙ୍କର ଦ୍ୱିତୀୟ ଏଭିଡେନ୍ସ ହଉଛି ସେ ଯୋଉ ଝିଅର ସାନ ଝିଅର ଡେଡ ବଡି ସେ ପୋଖରୀରେ ଭାସୁଥିଲା ଏବଂ ଆସିବା ସେଠିକି ପୋଷ୍ଟମର୍ଟମ ହେଲା ଇଟ୍ସ ଏ କେସ୍ ଅଫ ଷ୍ଟ୍ରାଙ୍ଗୁଲେସନ, ରାଇଟ, ଯୋଉଗୁଡାକ ମାନେ ଏଭିଡେନ୍ସ କ୍ଲିୟର। ବାକି ଯୋଉ ଆପଣଙ୍କର ପ୍ରେଜେନ୍ସ ଯୋଉ କହୁଛନ୍ତି ସିଏ ବି ଥିଲା, ଝିଅଟା ଥିଲା, ବଟ୍ ଦେयर ୱାଜ ଏ ଗ୍ୟାଦରିଂ ଅଫ 60 to 70%। ଗୋଟେ ଏମିତିଆ ସିଚୁଏସନ ନୁହେଁ ଯେ ସିଏ ଏକୁଟିଆ ଥିଲା ଆଉ କେହି ନଥିଲେ, ସେଇପରି ଅବସ୍ଥାରେ କିଏ ଗୋଟେ ଦେଖିଲା। 60-70 ଲୋକ ଅଛନ୍ତି, ସିଏ ବି ବସିଥିଲା ସେଇ ଇଏରେ। ତେଣୁ ଏତିକି ହଉଛି ଆପଣଙ୍କର ଏଭିଡେନ୍ସ ଆସୁଛି ଦେଇଛନ୍ତି ନା ଆଉ କଣ ଅଛି କହୁନାହାନ୍ତି। କାରଣ ଯୋଉ ନଖଟାକୁ ଇଏ ହେଇଥିଲା ସେଗୁଡାକ କିଛି ଆସିଲାନି।
ନା,
no blood,
but the earth
thyroid gland भी किसी
63 page. Yes, sorry, 64. 63.
63.
Yes,
on that.
That forensic laboratory result, that is result of execution. The exhibit marked as C is found to contain earth. The earth collected from the nail clipping marked as exhibit C is found similar to the sample earth.
Nail clipping report अपना page पूरी अच्छी, no blood.
Blood नहीं, किंतु चेते जे earth टा पस्तिला थी जागर, the spot रो earth. Spot रो
nail clipping of whom?
Accused.
Oh, that is the sample earth.
Yes, yes.
The sample earth
from the spot to
found in the nail.
Nail.
Is that of the spot?
Yes.
Seta kahin?
That is
the earth collected from nail clippings marked as exhibit C is found to similar earth marked as exhibit B with respect to the P. That is ମାନେ ଗୋଟେ ମା ବସିଛି ପୋଖରୀ କୂଳରେ ଏବଂ ଝିଅ ମରିକିନି ଭାସୁଛି, ତା ଧର ନଖ ପଶି ଯାଇଥିବ, ସେ ମାଟି ଲାଗିଥିବ ତା ନଖରେ। ଏଇଟା ଗୋଟେ କଣ ଏମିତି ଏଭିଡେନ୍ସ ଆସିଲା ଯେ ତାକୁ ଆପଣ why she has two daughters, why she would kill one?
No, no, সেটা তো সেই যে आवश्यक କିଛି ମୋଟିଭ ଦିଆ ହେଇନି ଯେ
ମୋଟିଭ କିଛି ଦିଆ ହେଇନି କିନ୍ତୁ 313
circumstantial evidence ରେ
yes
ଆପଣ motive assumes pertinent significance. It's not a direct case. ତେଣୁ ଦିଟା ଝିଅକୁ ତାର ଅଛି ଗୋଟେ ଝିଅକୁ କଣ ପାଇଁ ଇଏ କରିବ ସିଏ ମାରିବ ମୋଟିଭ ଟା ଆପଣ ଯୋଉ
ସେ ତାପରେ ଏକ୍ୟୁଜ ଷ୍ଟେଟମେଣ୍ଟ ସେଗୁଡାକ ଆସିନାହିଁ ଯଦି ସେଇଭଳିଆ କିଛି ଥାନ୍ତା ତା ହଜବେଣ୍ଡ ତାକୁ ସେକେଣ୍ଡ ଚାଇଲ୍ଡ ବେଳକୁ ଗାଳି ଦେଲା no such material is also there. True that she was not found in the house and she was sleeping along with the child and it is mother is the best person to say. 106 is a question.
ତାପରେ ସେଠି ଏକ୍ସାମିନେସନ ରେ କହୁଛନ୍ତି police it is a fact that I could not ascertain about the person who had seen the alleged murder of the deceased girl by the accused as alleged. I had not suspected the informant as the author of the alleged crime.
ଆଇଓ
ଲେଖିଛନ୍ତି
ଆଇଓ ଲେଖିଲା ଆଇଓ is not a witness. Who could be the best person to say where the child
the mother
and the child was sleeping with the mother. Mother uthikiri, what is the reaction if she did not find also? Did she speak to the husband that where is our child? No. And she was not found in the room.
ତାର ଗୋଟେ ଆପଣ
ମଦର ଟା ସେ କହୁଛନ୍ତି ସେ ଆଗରୁ ତାଙ୍କ
ମାନସିକ
ଅବସ୍ଥାରେ ଆଗରୁ ଥିଲା ଏବେ ବି ଅଛି
ମାନସିକ ସେ ଯୋଉ it's a fact that my wife mental retardedness prior to the allegations and also as on the date of ଏଇ ଲାଇନ ଟା
that is not
medical checkup ବି ହେଇନି
that is not the defense
ଆଣିଛନ୍ତି ଯେ but ଧର ମାନସିକ ଅବସ୍ଥା ଇଏ ଥିଲା ସେ ଦିଟା
that is not also corroborated by any other
ସେଟା ନୁହଁ ଯେଟା ସେ ଦିଟା ଛୁଆକୁ ନେଇକି ମନେକର ପଳେଇଲା ସେଇ ଅବସ୍ଥାରେ
ତାପରେ ଆଇଓ ବି କହୁଛନ୍ତି I had not seen the accused then and there cross examination ରେ କହୁଛନ୍ତି
So have you got any decision? Suppose the accused admits in the accused statement that if he has committed the murder, what would be its effect? 313 statement re जो questions गुड़ाक पचरा जाइए आपको सब गुड़ाक सत कथा आपन कहते आपण PW1 रो एविडेंस सत PW तापरे PW क्वेश्चन नंबर 5 रे मध्य से कहउछन हम मु फोपाडी देइथिली हला क्वेश्चन नंबर 3 रे कहउछन PW हम मु मारी देइछि एवं 6 रे कहउछन या सत कथा पॉइंट पाकरे जो ये एंड लास्ट जो दीटा क्वेश्चन हमें प्रथम आपन को पढी सुनेइलु चिपी मारी झील को पानी को फोपाड़ी देइथिली एवं सेदिन मोर मन भल नथिला राति उठी दुईटा जाक छुओ को सांगे नहीं गली महादेव बंध पाखरु सान झील को तंटी छाती मारिदेली और बंध पानी रे फोपाड़ी देली accused statement रे 313 statement रे गोटे accused जदि एई प्रकार statement admitting his guilt and whatever the witnesses are telling तमाने से जहाँ कहउछन्ती हां एटा ठीक बेली then what would be its effect how the court is to assess that accused statement एई जो evidence तो रहला गोटे side रे what my esteemed brother asked you a pertinent question आपण को झियो दीटा सहित सोईथिले गोटे खटरे जो रूम रे आपण को स्वामी भी सोईथिला पुओ भी सोईथिला स्वामी उठुचंदी देखुचंदी जे स्त्री नाही छुआ दीटा नाही तेणु आपण जदि छुआ संगे राति रे सोईथिले खट उपरे से रूम रे नाहांती तेणु आपण को ऊपर बर्डन शिफ्ट कर जीवो 106 अनुसार आपण एक्सप्लेन करिवे जे आपण से छुआ को नहीं कोन कले ତେଣୁ ଆପଣ ଏକ୍ସପ୍ଲାନେସନ ତ କିଛି ଦବା ଦୂର କଥା, ରାଦର ଆପଣ
ନିଜ
ଆଡମିଟ
ଉପରେ ଦୋଷ ଟଙ୍କା
କରୁଛନ୍ତି
ନେଇଯାଇଛି।
ଯେ ହଁ ମୁଁ ନେଇକି ଯାଇଥିଲି, ମୁଁ ତାଙ୍କୁ ତଣ୍ଟି ଜଣକର ଚିପି ଦେଲି ଏବଂ ତାକୁ ଫୋପାଡ଼ି ଦେଲି। ତ ଏଇ ଟାଇପ ର ଯଦି ଆପଣ ଆକ୍ୟୁଜ ଷ୍ଟେଟମେଣ୍ଟ ରେ କୁହନ୍ତି ତାର ଇଫେକ୍ଟ କଣ ହବ, ତାକୁ ହାଉ ଦି କୋର୍ଟ ୱିଲ୍ ଟେକ୍ ଇନଟୁ ଆକାଉଣ୍ଟ।
ଦେଖିବି
ଏବଂ ଆପଣଙ୍କର ଯୋଉ ଷ୍ଟେଟମେଣ୍ଟଟା ଦଉଛନ୍ତି that is being corroborated by the medical evidence. ଆପଣ କହୁଛନ୍ତି ନା ତଣ୍ଟି ଚିପି ମାରିଦେଲି ବୋଲି, ସେଇଟାକୁ corroborate କରୁଛି medical evidence। ତେଣୁ ଏଇ circumstance ରେ what would be its effect?
ଦେଖିବି
313 statement ର decisions ଦେଖନ୍ତୁ ଏଇ effect ରେ 106 ର evidence act ର ଦେଖନ୍ତୁ, 313 CRPC ଉପରେ ଦେଖନ୍ତୁ, accused ତାର accused statement ରେ admit କଲା, what would be its effect? Number 2, 106 of the evidence act ହେଲା, ତା ଦେହରେ କହୁଛି ଯୋଉଟା ଆପଣଙ୍କ ସ୍ପେଶାଲ ନଲେଜ ରେ ଥିବ, ତେଣୁ ଆପଣ ସେଇ ଜିନିଷଟାକୁ ବର୍ଡନ ଅଫ ପ୍ରୁଫ ଲାଗିଛନ୍ତି, ଆପଣ କଣ କଲେ ସେ ଛୁଆ ଦିଟାକୁ, ତେଣୁ ଏଠି ଆପଣ ଏକ୍ସପ୍ଲାନେସନ ଦେଇନାହାନ୍ତି, ତାର ତାହେଲେ କଣ ଇଫେକ୍ଟ ହବ 106 ଏଭିଡେନ୍ସ, ତାକୁ ଦେଖନ୍ତୁ, ୱିଲ୍ ଟେକ୍ ଅପ୍ ଦିସ୍ ମ୍ୟାଟର। We are taking up this matter on Tuesday. 17th we'll take up, because tomorrow after lunch there is a different other bench is there. So अच्छा हाँ, just by the way contact ही करना कि से number टा जो
ये जो number टा लिखी चाहिए था,
One of the goodness of
19th.
right, all right,
19th madam,
हाँ
19th
17th रो ऊपर थिबो, अपन 19th रे करिवे, हला ठीक है।